John.
Hey, John.
Hey,
Hey, John.
Amy. Hey, Patrick. Hey, Drew. Hi, Suzanne, Bob, Dave. Good. Jane called me and said she might not be joining us tonight. She's got something going on. She's going to try to get here if she can.
Oh, all right.
John, do you have two devices open? Ah,
Wi-Fi.
You're pressing the wrong.
I can't get on here.
No, we hear you now.
Someone can hear me?
Yeah, we can hear you.
Why does it say I'm in a practice session?
I don't know.
Okay,
Mine says
thank
live.
you.
I don't know.
I don't know either. Okay,
We're in a practice session.
all right, I need
And
glasses.
that meeting hasn't started yet, so that's why it's saying practice session.
Oh, okay, thanks, Mike. God only knows I need practice.
Mike, mine says live on YouTube.
Right, it's gonna be streaming once I hit the start webinar.
Oh, okay. I almost had a panic attack. Good. Okay.
I think it knows I need practice. All right.
Okay, can you hear me okay, Bob?
yes, I can.
Okay, it's 7:01. Hey, Drew. Hey, Dave. How are you?
Hey, John.
Hey,
Patrick, yes.
are board members ready to go?
I am.
Okay.
Jane's gonna be a little late, right?
Yeah, something's going on. She said she had a family issue, so
Yeah.
she'll get here as soon as she can.
Yeah.
And Amy, can you tell if we have George Pucci out there?
I'm not going to be able to tell until we go live for the attendees.
Okay. Okay, well, it is right after 7 o'clock, so if everybody's ready, we can go live and get this meeting going.
Mike, do you have the thing to go live? Because I don't.
Yep, we're live now. We're good to go. I'm gonna hand
Okay.
off to you.
Thank you.
Good evening. This is the Walpole Zoning Board of Appeals. Tonight is Wednesday, May 5th. It is just after 7 p.m. The first public hearing we have is case number 2025. This is for 300 Stone Street. This is a remand from land court relating to the decision of the Zoning Board of Appeals that was filed with the clerk on January 4th, 2021 for a special permit under section 11 of the zoning bylaws to allow the construction of a single-family dwelling in an area designated as floodplain district in zoning district residence B. So good evening, Mr. Pucci. Nice to see you here from Town Council. How are you?
Good evening, Mr. Chair. Very, very well, thank you.
So, George, as we open this hearing and we get the applicant in here, we haven't had any additional filing that I've seen. So what I'd like you to do is just explain to the board members and myself where we are on this this process. We had the the zoning board denied this request for a special permit in the floodplain, and it went to land court, and then you can bring us up to date once the applicant gets here. Okay.
Sure. Want me to do that now or wait for the applicant?
Amy, is Rob Truax there?
No, so I sent him the Zoom info yesterday. I haven't heard from him and I don't see him in the attendees.
I should note, I had been or the attorney for the applicant had been in touch with me. He might be waiting to get in, Attorney Almeida. We had, once I explained to the board, it may be a fairly brief conversation tonight to get the ball rolling on that. I'm obviously prepared to give you the background of how it's before you tonight, but I don't know if Rob, is even planning on being present for tonight. I haven't been in touch with him.
Suzanne, go ahead.
What's the attorney's name, please?
That's Attorney Brian Almeida, Almeida.
Do you know his address?
Yeah,
No.
Suzanne, he's with Connor and Hilliard.
Yeah,
Yes.
so I've have used his dad. So I may have to step down maybe.
Wow.
I don't know how that works. You can help me with that? I have.
Well,
used
I
his
mean,
dad
the,
as an attorney
the
in
general
past.
rule is, do you have a financial interest? Do you or a family member have a financial interest in this application? I mean, that's kind of the general
Negative.
rule, right? So
I
I don't see an issue, but it's up to
Okay.
you.
So I don't see the attorney in the attendees.
Okay.
I mean, I'm prepared to bring you up to date right now if you want, unless you want to defer. And I
No.
can update him after.
No, George, would you bring us up to date what's going on and where we're at with this
Great.
new filing? Thank you.
Great, thanks. Good evening again, Mr. Chair, members of the board. This is George Pucci from KP Law, Walpole Town Council's office. This application for a single family residence was denied on a 3-2 vote of the Zoning Board of Appeals. From my experience with your board, you tend to really do a lot of due diligence and a lot of great questions. And from what I've seen, you usually have pretty good consensus on votes. So, I was surprised by the 3-2 vote. I got the case after the fact, after it was filed. What happened was you denied the application on the 3-2 vote. That appeal was denied to the Massachusetts Land Court. And the plaintiff's attorney served the town clerk with the complaint, and then it came my way through the town administrator to answer and defend on behalf of the board. The town administrator doesn't have jurisdiction on the application, but he knew about it, and in the great way that Walpole runs its business, the town administration is always looking for ways to streamline or cut down on possibly unnecessary litigation. So, he had expressed an interest for us to look at it and see if there was any potential resolution. I conferred with the building commissioner mainly by email about his take on the application and the bylaw provisions at issue. The former community development director, Ashley, before Pat was on board, had a suggestion about possibly putting the application on for peer review. With an appropriate peer reviewer to be selected by you and to look at the issues and the denial, and possibly, look for ways that you might be able to condition the application. So what happened was the land court holds what they call case management conferences very early on in the litigation. And when you're in litigation in land court, you'll be assigned one land court judge, and that particular judge will take the case all the way through to conclusion. So we did discuss at the case management conference the possibility of, either some type of alternative dispute resolution wouldn't be appropriate because it's a permitting issue. It really has to come back to you. But, the amenability of possibly taking a second look at it and see if, the application might stand a better chance the second time around after peer review. And so with no prejudice to your rights to defend the denial decision, the judge remanded the case to your board for a remand public hearing. So the remand hearing is a formal public hearing. You're free to ask as little or as much as you want. You're free to hear it de novo. You're free to hear from public comment if necessary, or any other way you want to hear it. And then ultimately, though, we would need a decision from the board on remand. And in the event a permit is issued, that would render the lawsuit moot, and that would be dismissed. In the event that it results in another denial or an approval with conditions that the applicant was unhappy with, then it would just go back to land court the way it was before. Nobody's rights are prejudiced, and the plaintiff can proceed with the appeal of the denial, and we can go ahead and defend it in the land court if that's how that ends up. So this is basically just a second time around. And again, on a 3-2 vote, and with the benefit, and I had conferred with plaintiff counsel, and the applicant was amenable to paying for suitable peer review if that selection could be made, and they would be amenable to that. And then what I would recommend, if the board was interested in that you continue tonight's hearing, we get the peer review selection in the works, and maybe have it teed up so that you could have that review done by the next time of a continuation of this hearing. So that's in a nutshell. That's kind of a lot that I've relayed to you, but that's basically it. And I'm available for any questions. I see Attorney Almeida is here now.
Yes, Mr. Chairman, I've been able to listen to everything thus far. I think I was just muted in a way that I couldn't unmute myself. So I've heard everything thus far, and I completely agree with everything that Attorney Pucci said thus far.
Okay, thank you. So I've got a couple of questions on this. George, I think the way to go would be to, if we went with your approach, to obviously continue this hearing, but in this time, we would have to find somebody for peer review, get a price for the peer review, and then come back, and then the applicant would have to agree to the cost of the peer review. Because right now we don't have a cost for a peer review for something like that. So I don't think we could go forward with that aspect of it. The other thing is, board members, I thought it was a 4-to-1 vote. Does anybody remember what the, Amy, you wrote the decision. I thought it was 4-to-1. Do you remember what it was?
I can look it up. Just give me 1 second.
Okay. Does anybody else have any questions procedurally where we are? Go ahead, Suzanne.
Do we have to do like a regular refile of butters and all that?
No.
So no, the abutters don't know this is going on?
Yeah, it was noticed as a public hearing, right, Amy? Everybody's been noticed as just like a regular public hearing.
Okay. And it says the word remand to the public? Okay. I don't know if they know what that means.
Well, they know it's a notice public hearing, that's for sure.
Okay.
So.
Okay. I just know how I voted. I really don't know what the vote was. I know this area very, very, very well. I could walk blindfolded through this property.
So at this point, do we have anybody from the public that wants to speak on this? Because it was noticed as a public hearing, and it looks like we are going to continue it tonight. Is there anybody in the public to speak on case number 2025 for 300 Stone Street?
I don't see anyone in the attendees with their hand raised, but the vote was, you voted no, and so did Suzanne. So it was 2-3. Okay. So
Just a quick question, Mr. Chairman.
Yeah, go ahead, Bob.
I don't know, George, if there was any discussion about the scope of work for the peer reviewer in this case. I know that the special permit criteria are laid out in section 11, but was it the intention that someone would review the plans and sort of give us their sense of whether they comply with that section, or what was there anything discussed in that regard?
No, the parameters of that was not discussed, just the concept that the plaintiff was agreeable to. So, that you're free to discuss that in this. You're free to let Pat kind of take the ball a little bit and see what he can, come up with to bring back to you. It's totally up to you how to deal with that. And again, no pressure for this at all, and no disrespect to you, Mr. Chair, or the other member who voted against the application, because like I say, it's no pressure at all. There's a complete reservation of your defense rights on the denial. So I just hope that, this remand effort is seen by, the board as just, a good faith effort at seeing if it can possibly be resolved.
Right. None taken. I understand where that's coming from, and if things can be resolved, that's a good thing. But we're going to have, it's a new hearing, so we have new evidence, and they'll present it, and we'll have a peer review and see where we're at. I also see we have Mr. Yanovich on the screen here. Mr. Yanovich, do you want to comment on this?
Thank you, Mr. Chairman. Yeah, I won't say much more than town council has said, but the only thing I can lend in my experience in dealing with remands back, which is a fair amount of cases, is, with all due respect, the fact that people know the lot is not really much of a defense on the town side. Really, the remand is to say, okay, let's deliberate based on what the bylaw says for this particular section of the bylaw. So in taking this case on remand and recounting what the testimony was, and having the offer of, a peer reviewer to rectify the issues with flood zone, which is, the federal flood program puts the flood requirements in either the zoning bylaw or the local general bylaw. So there are conditions placed on construction in flood zones. So just something to consider is deliberation based on what the bylaw says, and not necessarily, personal opinion on that lot. So that's the only thing I have to say based on my experience. Obviously, it's the board's responsibility to render a decision. But in my experience, that's what I've dealt with.
Okay, thank you. And I don't believe Ms. Murphy was talking about
Ms.
personal.
Murphy's here. Ms.
Yeah.
Murphy's here. Well, you're getting wound up here now.
Okay.
Woo-hoo!
The point was, Suzanne grew up in that area. She knows the area very well. That's all.
Yes.
I think that's all she's saying, that she knows the
Yes.
area probably better than anybody on the screen. So,
Yeah.
but the question is, how does that knowledge transfer over to the bylaw? And I also know Ms. Murphy knows the town bylaws quite well. So, okay. So why don't we do this? Why don't we continue this out for, Amy, what do we have about a month from now, where we could, in that time, the zoning board will get a scope of work for what it will take, and an estimate from some companies for peer review. What do we have?
We have June 2nd.
Okay. Is that okay with Patrick? You'll be doing some of this work, finding a peer reviewer. Is that sufficient time, do you think, to find a peer review and get a quote to get this work done?
Yeah, I'll start on that tomorrow, and that's more than enough time.
Okay. Mr. Almeida, is that okay with you?
That works. Thank you so much.
Okay. Okay, so this case will be continued until June 2nd, at which point hopefully we'll have some more information.
So moved.
Okay. June 2nd at 7 o'clock. Okay. So moved by Suzanne. Could I have a second on that?
Second.
Second by Bob. Any further discussion on this before we vote? Everybody's good? Okay, this is to continue it out until June 2nd. Roll call vote. Bob Fitzgerald,
Aye.
Suzanne Murphy,
Murphy, aye.
Drew Delaney,
Aye.
and Dave Anderson.
Aye.
And I'm John Lee, aye. Okay. So next we have case number 0519-2, Wall Street Development Corporation, 48 Burns Ave. And this is for parcels at 48 Burns Ave, Union Street, Brook Lane, and Burns Ave, parcel 20-137. Request for project change modification for a comprehensive permit dated 1/26/21 and modifications with subsequent letter on 2/10/21 under Mass General Laws 40B to amend previously approved project to include modification conditions and the decision to file with filed with the town clerk on January 13th, 2020. Okay, now we have town council with us. Mr. Pucci, at the last meeting, there was quite a bit of confusion for some of the board members. What are we actually looking at? And can you explain, is this involving the modified project involving Brook Lane property, or is that, where are we at on this? Can you explain that, please?
Sure. This is, it's actually not as complicated as it may first appear. You'll recall you granted a comprehensive permit for Burns Avenue 40B a while back, several months back, and pre-pandemic, back in the day. And that comprehensive permit decision was appealed to the Housing Appeals Committee. The applicant subsequently filed a notice of project change that you determined to be a substantial change. And that was the big one that he had proposed with the new access and egress point. So a second access egress point in addition to the original. That notice of project change came back to you. You opened the hearing. There ended up being a dispute over peer review selection. And you ended up actually denying that notice of project change, which was that big substantive project change with the new added access and egress or access and exit point. You denied that. The applicant filed an appeal of that denial to the Housing Appeals Committee. And that's done just the way any permit appeal would go to Housing Appeals Committee. And that appeal is pending at the Housing Appeals Committee with some preliminary motion practice back and forth. Ultimately, the HAC will render some type of ruling on that. It's, not really relevant to you trying to sift through what's before you tonight as to the nature of that ruling. We can get into that, but that process will be going for a while before when and if anything comes back to you on that. Then you had fairly recently a project change that involved the time of construction, like the school children in the area issue. And I believe that you went ahead and you denied that project change, and a decision that's been issued on that. This project change now before you tonight was the one that involved some Conservation Commission permit conditions and possible revisions of those conditions. And that's the one that's before you tonight. And you have made a determination already that it's a substantial change and it requires a public hearing. And you are now in that public hearing process on that notice of project change on those distinct issues. So you would need to render actually, I think the deadline for closing the public hearing on that is tomorrow. So if you don't get to the end point on that tonight, you would need an extension to keep the public hearing open. If that's not necessary, or if that's denied, you do have to go ahead and close the public hearing on that at some point tonight. And then you would have to issue a decision within 40 days. So you would have time to deliberate after closing the public hearing, but you won't, without the applicant's assent, you won't be able to continue the public hearing beyond tonight.
Okay, so I followed everything there. The one thing that I thought that the Brook Lane, the modified plan, I thought that was, we voted that down, and the, I guess the applicant appealed to Housing Appeals Committee. That I was not aware of, so that's fine.
Wait, which one, John?
You said that the applicant appealed the modified plan, which we had a dispute over peer review.
Yep.
So does the applicant have two appeals going on at Housing Appeals right now for this project?
He has the original appeal of the original permit. That's still live, but it's sort of taken a back seat now to the second appeal, which is an appeal of the denial of the project change relating to the project changes with the additional access exit point to the development. And that appeal arose from the dispute over the peer review. So it's really one appeal, but those are two distinct, appellate events that are before the Housing Appeals Committee and not before you. Both the appeal of the original comprehensive permit decision and the appeal of your denial based on the peer review issue.
Okay, and what we're dealing with tonight are conditions that were in the original decision back from January of 2020.
Exactly right.
Okay. Board members, do you have any questions where we are procedurally? Go ahead, Suzanne.
Definitely. What particular things are we doing tonight pertaining to the first one that we already approved that the applicant is also appealing, like he's appealing the second one that we denied?
Nothing. You're acting on the small bucket of proposed
Nothing
modifications.
small. Nothing small. Which one? What do we do?
However characterized, the bucket of proposed changes, and I think it was provided to you in one package, and they related. I don't know the date offhand that it was submitted. Patrick knows, I believe.
So I believe there was an original letter from January 26, which was amended on February 10th, detailing 1, 2, 3, 4, 5, 6, 7, 8 conditions. So those conditions, that's what you deem to be substantial during the first meeting on this modification request. And this is now the third public hearing with this specific modification request to the original January 13th, 2020 decision.
That's correct. And that's the bucket I referred to, quote unquote, those 8 conditions. And you had received input from the conservation agent at some point. I believe Ashley put a recommendation together or something that she sent to.
So Ashley had reached out to the town engineer and the conservation agent for review of the conditions for their input, as well as whether or not the modification request was appropriate. And so that was the letter that was sent out, I believe on March 24th to the board. I don't know, Amy, if that's exactly correct, but that's the kind of response from the town side to the modification request from Mr. Petrosi.
And I can take that one step further. Suzanne, you received an email on May 3rd.
May 3rd.
May 3rd, and it says requested modifications. It's a Word it's a Word document, and it lists out starting with point number 2 to 9, and those are the 8 issues that we're discussing tonight. So that's where we are. And as George said, it's a bucket of 8 items. And a lot of it had to do with clarifying some things. The first one, putting an actual dollar amount on the technical review for this. And we can go right down, and once everybody finds that document, if it's helpful for everybody.
I can't find, is it clarification of Burns Ave 40B hearing? Is that the document?
No, it was sent on
That says sent May 3rd.
May 3rd.
Okay. To Ashley Clark. I don't know. Might be it. I don't know. Maybe someone needs to send it to me. I
I'm
don't
doing
know.
that right now.
Thank you. I got a whole mess of them, so.
Right? No, I understand.
So can I just ask again, how many modifications have we already done on this project, not including the one with Brook Lane, on this project, the 3rd time around?
Not really as many as you may think. It
We
seems
did-
like a
we-
lot.
We did the one where the applicant told us no children live there and there are children live.
Yeah.
So we're keeping the time. We voted on that.
Yep.
What other ones have we done?
What I just said, the notice of project change for remember
Time.
the bigger one. No, that one's done. That's
Okay.
one. Yes, one.
One. So
Done.
now we're down to 7.
No, we're down to 2. So the second one is, I'm sorry, through the chair, can I answer this question or no?
No, you said we're down to 2. We're actually down to 8 modification requests, I think, George.
No, but it's in one. Well, that's important to note. That's one modification request. So don't think that you have the ability to hear all. In other words, the public hearing will close on all 8 of those. That's why I'm saying that's only one. And that's what I meant by a bucket of proposed changes that are in one notice of project change that you need to act on. So that we'll call that the second one. So that is the one that Patrick just described that you're sending around, that Ashley had given recommendations. So when I'm distinguishing between, right, there are multiple conditions at issue, but I'm talking about the operative event of a notice of project change that, sets into motion a bunch of requirements that you have to comply with. Of those, there are only 3. The one you just talked about the school children, you denied that, that's done. This bucket of 8 conditions, that's the second one, that's before you tonight. And the other notice of project change was on that bigger, more substantial change that had to do with adding an access exit point to the development. That was another notice of project change. You never ended up having any type of substantive discussion on that because of the dispute over the peer review. That matter is no longer before you because you issued a decision on it. It was a denial decision, and that has been appealed to the Housing Appeals Committee. So now you have so in total, there have been 3 notice of project changes. You only have 1 in front of you tonight involving 8 conditions. Yes? No?
So, yes. And Suzanne, did you receive the email that I just sent over?
No, not yet.
Okay. Well, so this is the one that outlines the conditions. It shows the conditions that the zoning board put on the decision, and then the request modification, and then a staff comment on this, on each one. And at the last meeting that we had, we went through these, and I know it was getting confusing, but this is what we have in front of us. And if you have this document, it lays out all 8 points clearly. And I don't know what else to say on this. we need to go through these 8 points and discuss whether we would approve these modifications. Bob, you're always good at explaining things.
Can I just ask a question? Maybe I can sum it up. So the applicant is now going back to the first one that we approved and tearing apart our conditions to make them suit him better?
One,
Is that-
one could characterize it like that.
Is
I
that
mean, he
what we're
wants-
supposed to be doing here?
Yes,
Because
he's
he
looking
didn't
for,
like I mean, am I supposed to turn around and change everything that I did the first time to make him happy? What?
you are, all you're obligated to do is what you're legally obligated to do. You've
Right.
made a determination that it says it would constitute a substantial change. That triggers an event, which is a public hearing on that bucket of proposed changes. You are within that period and you only have 6 months to conduct the
Okay.
public hearing. You're on the eve of that needing to be closed. And that's
Okay.
what you need to do. However you want to characterize it.
No, but that's
You have a
that's
legal
basically-
obligation unless you want to do a constructive approval
Well,
of
I'm trying
acting
to
on
get
these.
through I'm trying to get through the head here, and that's what I'm coming up with is he's going back to our original approval and just trashing as best he can our conditions and coming up with his own,
Suzanne, I don't think
Yes.
he's trashing it. What he's saying,
changing them.
well, what he's saying is these need clarification or
Okay,
he doesn't like them. I don't know, but he's
not
appealed.
trashing. Sorry, I used the word
He's
changing.
appealed these 8 points of our many point decision.
Okay,
And these are the ones that he's appealing. And
okay,
when you look at the document that we have, it outlines them. And for the most part, in my opinion, it's just a lot of almost like housekeeping issues where before we had said on the first one, retain outside experts for technical and legal reviews. That's what we said. Now we're going to clarify it because we're going to actually put a value on it. We're going to say a check in the amount of $5,000 to pay for those reviews.
and have we received that?
No,
You
because
wouldn't
we
have.
haven't voted on it. Go ahead, George.
I'm
Okay.
sorry, I shouldn't have interjected. I apologize. But no, you wouldn't have. He's
Okay,
trying to modify it to clarify what it is.
but how will we get that check if the hearing is closed tonight? We can't accept anything.
It's not relevant. It would go to when the permit becomes operative. So he's just looking to modify certain conditions in the original approval, to clarify certain things, make certain things from his perspective consistent with like a subsequent order related
Okay.
to conservation, things like that, cleaning up various items that he thinks need clearing up or cleaning up. And he's seeking that from you in the form of a project change.
Wouldn't we need the $5,000 before we close the hearing if it's for a peer review?
It's not for peer review, it's for review after, right, with compliance with conditions of the permit, right?
Okay,
It's not,
Okay.
it's not to hear the application.
Suzanne, do you have the document in front of you?
yes, I'm reading it. That's why I saw the 5,000 right up
Okay.
front.
So the 5,000, and it doesn't say peer review, if you notice, it says
No,
technical.
it says technical review.
Right.
Right.
Okay. So, Bob, do you have anything to add?
I think George summarized it fine, and I think we're, just working our way through this list and deciding whether or not we're amenable to making the modification.
And George, just one procedural question. On these, there's 8 items. We can pick and choose whether we might like number 1 to 7, but we don't like number 8. We can do that, right?
Yes, it would be a decision after you close the hearing, and that would be specified in the decision.
Okay.
You had me worried. I thought I was a real fail here on the explanation.
No,
You were
it's just
grasping
me.
for other
You did
explanations.
fine.
No, I'm just kidding.
No, you did fine. I'm just,
Needless to say, this has been a very complicated process and not the way the zoning board normally handles things. And that's just the way this case has become. That's what it's become.
George, how many times have you done buckets? I mean, I've never done a bucket, I must say. My first bucket.
Okay, so let's go through these. So if you take a look at your sheet of requested modification, condition C1A, I'll just start out. It seems like a reasonable modification because what we're doing, we're actually putting in a dollar value at this point for this. And staff comments said that they believe that $5,000 should be sufficient. Does anybody have any other comments or questions about the first one?
Why does it say beta on March 11th, 2021?
So we were not going to use beta for the previous project, but this one, because it's a review of the project that was done by beta, Tetra Tech said that they would not do the work. And the reason they wouldn't do the work is because all this works up to this point has been done by beta on the peer review for this. Does that answer your question, Suzanne?
But who's going to check what beta does?
Beta's working for the Zoning Board of Appeals on this one because they did the original work. Tetra Tech will not do this work. Tetra Tech has turned to us and said, we're not going to do this work because this is a beta project. They've been doing the peer review. They should continue doing the peer review, even though we asked Tetra Tech to do the work. Patrick or Amy, do you have any clarification of that?
Yeah, so I believe the way you described it is how it was relayed to us. Also, by beta reviewing the scope of work and providing the estimate of $5,000, that is their estimate that is the extent of work that is needed for technical assistance review of this request. So I believe that beta would be the company that would be used for this technical review, but it's also just a general review of how much funding is needed for the certain amount of technical work.
And again, this is not a peer review. This is technical reviews after the project, if approved, moves forward. Correct, George? Right.
Yes, correct.
Okay. So, Suzanne, do you understand? You good with
I
that?
understand.
Okay.
Totally understand.
Okay, good.
Yes.
Okay. Bob, Drew, Dave, do you have any comments on this one?
I do not. Do we want to vote each one individually? Is that the way you'd like to proceed?
Yeah, we can do that, and then at the end we'll Amy, can you keep track of it like that? You comfortable with that?
Yeah, that's totally fine.
And Bob, is that something you're comfortable with, Bob?
Oh, yeah.
Okay. And town council, are you okay with us voting each one as we go through it?
Yeah, I think that would be a streamlined way of doing it. Then at the end, you could close the hearing, and after the hearing's closed, you could schedule deliberations to deliberate on a decision consistent with your vote tonight. That'd be a great way of doing it.
Okay, that sounds good. Okay, so the first one, this is number 2. That's how it's labeled here. Condition C1A, and we have the requested modification, and staff says that is the $5,000 should be reasonable. Could I have a motion to approve?
Do we need to just to check if there's anybody who wants to comment on this before, in the public, I mean, or the applicant for that matter?
Thank you. Is there anybody from the public that would like to comment on this modification?
No,
Okay.
I don't, there's no one.
Yep, and I just saw Kathy Campbell said, thank you, not on this one. So thank you, Ms. Campbell. Mr. Petrozzi, do you have anything to say on this?
Nope, I'm here.
Okay. Okay, so could I have a motion to approve this requested modification?
So moved.
Moved by Suzanne,
Second.
second by Bob. Any further discussion on this? Okay. Roll call vote. This is for the first condition, condition C1A. for the modification to approve it. Roll call vote. Any further discussion? No. Bob Fitzgerald,
Aye.
Suzanne Murphy,
Murphy, no?
Drew Delaney,
Aye.
and I'm John Lee. Aye. Dave Anderson, have you been here for all these hearings, do you know? Or Amy, do you know the answer to that?
I have not.
Okay, so it's going to be a 3-1 vote on that. Okay. I should ask, town council, majority vote because it's a 40B, is that correct?
Yes.
Okay, next one. This is condition C1C. Provide the board with the recording information documenting the fact that the order of conditions for the project issued by the Conservation Commission dated November 4th, 2019 has been recorded with the Norfolk County Registry of Deeds and that all appeals have been exhausted. And that the applicant has requested the modification to provide the board with recording information documenting the fact that the superseding order of conditions for the project issued by the DEP dated February 20th, 2020 has been recorded with the Norfolk County Registry of Deeds and all appeals have been exhausted. Staff comment is that engineering department has no objection to this modification. Anybody have any questions on that one? George, do you want to comment on, just for the record and for the public, the superseding order of conditions is what's guiding this at this point because the DEP stepped in on this, is that correct?
Well, yeah, I mean, to a certain extent, that's why Ashley had gotten the input from the conservation agent, because if you have more restrictive bylaw provisions and those are imposed, then the ZBA is exercising the jurisdiction of the Conservation Commission with respect to those. So any type of recommendation that the agent gave you be preserved from their local bylaw decision, you would want to incorporate yourself. But as to the state Wetlands Protection Act, and that's the state portion of a conservation permit, those are appealable to Mass DEP, and the state ruling is binding on you. So you can't supersede what the state does, but the state's ruling is relevant only to the State Wetlands Protection Act and the state regulations under that act, if that makes sense.
Well, now I'm a little bit confused because the Conservation Commission issued a decision back on November 4th, 2019. And what it looks like the applicant is trying to not have that filed with this decision. Why would we give that up if it's something that's still live and active?
Yeah, typically the reason for a modification arising from a superseding order of conditions is if the superseding order resulted in some type of modification of the plan. So in other words, you have an approved set of plans, their permitting and appeal process was still ongoing with respect to that. Your comprehensive permit is subject to all state rules and regulations. They have to comply with those separately. But typically the way this arises is if some type of superseding order from the Mass DEP resulted in the need to change the plans. Then they come back to you and they say, well, look, we're required by the state to do X, Y, Z, so we have to make these certain modifications to our plans or to your conditions in order to comply with that. And in those cases, I would always recommend that those changes be adopted and accepted, because you can't rule inconsistent with the way the state is on those issues. And so what I was saying about Ashley getting input is her input would have been focused on okay, Conservation Commission, is there anything that you need preserved by the ZBA that, you know, it is not covered in the superseding order? And that's where that comes in. So you're just, so you're trying to impose conditions that were imposed by the Conservation Commission, and anything that is consistent with the way the state ended up ruling on the State Wetlands Protection Act issues. So that was the reason I assumed that the conservation agent did review this modification request and weighed into Ashley about what her recommendations were. And what I would recommend, as I always do, is, you know, follow the recommendations of your local agents and officials when they comment to you, to give you input on issues that would otherwise be within their jurisdiction.
Okay.
If I may, Mr. Chairman.
Yeah, go ahead.
So Landis did provide her feedback just on this very point as what should be retained from the original, you know, based on the local bylaw as opposed to the superseding order under the state. That's the very last paragraph of this document. And she specifies what it is that she's recommending we not remove from the special conditions. So I think when we get to that last one is where the requested modification deals with incorporating terms and conditions from the prior wetlands approvals, and that would be the place to say whether we want to follow Landis's direction on that.
Okay, and I guess my only question on this, town council, is could we modify it so that we include the Conservation Commission's decision and also the Mass DEP superseding order of conditions? Could we have both, or does that confuse things even more?
That would confuse things. I would just follow you're free to reject the input from local officials too, but I mean, my recommendation would be you follow the agent's recommendations with respect to this modification on these issues.
So the one problem with this one is we have comments, staff comment from the engineering department, not conservation on this. That's why, but Bob pointed out that at the end, Landis has comments, but
no, if I could, this particular request is simply to say, do I have to provide proof of recording of the initially issued order of conditions, or do I need to provide proof of recording of the superseding order? It doesn't have anything to do with whether we should be preserving other conditions. That'll come at another request that's down the line. So I think this is strictly, as I read it, it's simply updating this provision in the permit to reflect the fact that a superseding order has been issued, and we want to make sure that that superseding order is recorded.
okay, I get that, Bob. Thank you. Okay, board members, any questions on this one? Okay. Does anybody from the public have any comments?
So Kathy Campbell has a comment. Whenever you're ready, Kathy.
Thank you, Mr. Chairman, Kathy Campbell. I just want to make a point that the superseding order of conditions that was filed at the Registry of Deeds dated February 20th of 2020 does in fact, as Mr. Pucci suggested, contain a different plan. That plan is dated January 20th of 2020. And I believe we'll get to that item when you get to the very last item, which is item number 9. But I just want to make sure, I think the last meeting we had, it was very confusing for me. The original permit that's sitting with the HAC has a September 2019 plan. When we get to number 9, the applicant is asking to replace that plan with a January 20th, 2020 plan. And then on the Walpole website, there's a February 23rd, 21 plan. that is labeled final ZBA conditions, and it is significantly different than those other two. So I really, I have no issues with number 3. I just want to make sure that if you're voting yes to number 3, you're also voting yes to, I think, the January 20th, 2020 plan that ZBA may or may not have seen. Thank you.
Okay, thank you, Mrs. Campbell.
That's a problem here. That's a problem.
Okay. So Suzanne, what's the problem?
Because like she's pointing out, now we're going from, this modification doesn't mention any plan that I see. Maybe it does. No.
These modifications are based off of what the board already approved back in January of 2020. That's what we're modifying. Town council, are we modifying anything more than the permit from back in January of 2020?
No. That's why you gotta, I would take them one by one, because what you want to do is you want to look exactly what the applicant is proposing. In other words, what is the condition? What number is it? How is it worded? How does he
And
want
what
it
plan?
modified?
In what
No,
plan?
no, if that condition refers to specific plans, then plans would be relevant. Otherwise, look at the language of the condition at issue, look at his proposed modification, and then determine whether you have enough information on that and determine whether or not you want to grant that or deny it. That's the way to do it. So if the condition at issue is not referencing any plans aren't an issue for that particular one.
Right. And what it's referencing is, the only thing it's referencing is the DEP superseding order of condition, which was approved after we closed our hearings. So it's sort of tying it all together at this point. Am I understanding that correct, town council?
Yes, and if he's looking for a modification of approved plans that you've approved, he's going to have to specify that. In other words, I have to amend this particular plan that you approved because DEP is making me do X, Y, Z. So unless and until he's asking you for that type of modification, it's not, just focus on the language of the particular condition at issue. That's what matters. Whether or not you want to modify that or not.
And if any subsequent change to a plan that occurred as a result of the superseding order condition is inconsistent with the plans that we've approved, then he has to come back and modify our decision to reflect those modified plans. But that's not what we're talking about right now.
Correct.
Okay. Suzanne, you still?
Why can't we just put the date of a plan on this vote?
I would respectfully just recommend you just focus on the language of the condition at issue. One by one. What is the language? What is the modification is seeking? Do you have enough information?
No.
And if so, are you going to approve it or deny it?
Okay.
So Suzanne, the date.
I don't have enough information.
Okay, but the date of the plan is the plan that was approved with these conditions back in January of 2020. That's the plan that we're dealing with.
Okay.
Town council, am I correct on that? That's the plan we're dealing with. The plan that goes with our original decision.
That's the approved plan. If he needs a modification of that, he has to request a modification of that.
Why can't we just put that? Why can't we
Well,
just put that sentence in this vote? Because
that's why I keep saying, just please focus on the language of the
Okay.
condition at issue, and then you can take them one by one that way.
okay.
Okay,
I mean, examine the language. I don't mean to be facetious, but read it out loud and say, all right, what is it really seeking? I mean, I don't want you to rush through it. I just, but you got to focus on the language at issue of that particular condition.
And this language involves recording the DEP superseding order of conditions. That's what this involves, and not the Conservation Commission decision. That's what we're dealing with here. Okay, and I'll also add that engineering department didn't have any problems with this, and Landis has comments later on for this. Okay. Anybody else that has a question or comment on this? Okay. Board members, could I have a motion to accept the requested modification change for C1C?
So moved.
Okay. Second on that?
Second.
Second by Bob. Roll call vote. Bob Fitzgerald.
Aye.
Suzanne Murphy.
A huge, huge reluctant aye.
Drew Delaney.
Aye.
And I'm John Lee, aye. So that's a 4-0-0 vote. Okay, the next one. Condition C2H. And the original condition was applicant shall provide security in the amount and form acceptable to the town for emergency sediment control and site stabilization. Requested modification states applicants shall provide security in the amount acceptable to the town emergency sedimentation, sediment control and site stabilization. Said security shall be provided consistent with provisions of general laws C41 section 881U as provided in condition 1.1 provided therein. And the staff comment is engineering department has no objection to this modification. So this has to do with, instead of a open statement that will provide security, it's actually tying it to the way bonding is done. Is that correct, George?
Yes, yep. Consistent with the Subdivision Control Act, I believe he's referencing.
Does any board member have any questions or want to make a comment on this? Suzanne, you've done lots of subdivision control, with the bonding.
Yes.
Are you comfortable with this? Do you understand this?
I understand it, but I don't know which plan it pertains to. Again, the January 20th decision?
Unless and until that's modified, yes.
Okay. I just wish it said this on here, and I know I'm being dumb and whatever. I know you're trying to be nice, but I feel it's very vague and it should say that.
Yes, I'm neither trying to be nice nor are you dumb. You're asking great questions. I apologize for not being as succinct as I aspire to be, but I just go back to my theme of just look at the language of the particular condition and let's deal with that. You have an approved set of plans. That's the subject of your approval. Unless and until he seeks a modification of those plans, it's not before you. If one of these conditions calls for that, then that's a different story. But let's see what they say and what they're asking.
Okay, I'm going to just take a moment. Mr. O'Leary sent an email. If I'm reading the Concom decision dated 11/4/2019, they based their decision based on plans dated 9/25/2019. Okay, so
Tell them, just read what it says.
Can I take a crack at this?
go ahead, Bob, because I can't. I don't have the Concom.
So the application to the Conservation Commission is under the Wetlands Protection Act as a state statute. We don't have any jurisdiction over that application. the applicant submit a set of plans to get approved by the Conservation Commission under the Wetlands Protection Act. And that those set of plans are what they are, whatever they happen to be, they are. And that was appealed to the DEP, and a superseding order was subsequently issued with a different set of plans, that because the DEP required some changes to the Conservation Commission's initial decision. So those plans aren't the same as what the original Conservation Commission approval was based on. But nevertheless, those are the operative plans under the Wetlands Protection Act. They're not operative under our decision the first time around. So whatever those plans show, they are, and we have approved a set of plans that are identified in our 40B approval. If there's any inconsistency between those two, that's not a risk that we're taking. That's up to the applicant to identify those. And if he cannot comply with our version of the plans because of the changes that appear in the superseding order of conditions plans, then he has to come to us and ask for a modification of the plans that we approved so that they're consistent with the superseding order. I don't know if that is clear, but
It's much better than the way I said it. Yes, that's exactly right.
so I understand that there's reluctance to kind of move forward because we haven't seen the plans that are tied to the superseding order of conditions. But those are not within our jurisdiction to review anyway. And as I say, to the extent that those plans are not consistent with the plans we approved, that's not on us to rectify. That's up to the applicant to have to come back to us and request a modification to the plans, not to the recording information in this particular one, but
Exactly.
an actual change to the physical plans that show the improvements.
Right.
And that's not what we're doing. We're just looking
Yes.
at which document do I have to record. That's really what this one is geared toward, and or the previous one was geared toward. Not, hey, I'm changing all of the rules that apply to me under the State Wetlands Act. That's not what's
Right.
at issue.
Right. Where the plans become relevant is if he's, whatever condition of your permit that's incorporating the approved plans, if he needs a modification of that, he has to seek it from you.
Okay. Suzanne, do you understand?
I think it's great we don't get to see the plans before we close the hearing.
Suzanne, the plans are the ones
The-
that
The Mass DEP plans.
we could have seen them if we wanted to see them, but that's really not before, that's not what's before us. What's before us is the plans that we approved. That's,
Okay.
okay, so this is for condition C2H. Could I have a motion to approve C2H?
So moved.
Moved by Suzanne, second for discussion,
Second.
second by Bob. Any further discussion on this one? And I do appreciate Mr. O'Leary for your comments out there. I appreciate that. Okay, hearing none. This is a roll call vote for C2H. Bob Fitzgerald,
Aye.
Suzanne Murphy,
Murphy, aye.
Drew Delaney,
Aye.
and I'm John Lee. Aye. Okay, so that one's approved. Next one, condition C2I. Applicant shall provide security in the sum of 125% of the bona fide estimate of the cost of restorative landscaping. These funds will be used to restore the site should the project be abandoned and no construction activity take place for 1 year. Requested modification. Applicant shall provide security in the amounts acceptable to the town for restorative landscaping to consist of loam and hydroseed of any disturbed areas. Said security will be provided consistent with the provisions of General Laws 41, Section 81U, as provided for in condition number I, 1, provided herein. And that's very similar to the previous one that we just approved, which involves the bonding for a subdivision. Any questions or comments on this one?
So I think the staff comment here was that not so much as to the form of security, but the scope of what landscaping, restorative landscaping would be, whether it would consist of loam and hydroseed as proposed by the applicant. And Landis is indicating that it could be more than loam and hydroseeding, and it could require planting of plants as well. So I don't know if the applicant would like to speak to that or whether you're amenable.
Well, Mr. Chairman. So, restorative landscaping usually refers to restoring it to the condition of the property that was existing prior to commencing construction. So in this particular instance, there's no loom and there's no hydroseeding and there's no plantings on the property that would be considered that you'd want to restore. I simply don't understand the condition to begin with, but restorative landscaping in this particular instance would not include any plantings. It would simply be a looming and seeding operation, not plantings. I will point out, though, if we are proceeding in the project according to the order of conditions, then one of the priority or one of the first steps that we are required to do is do the restorative plantings along the 25-foot buffer zone that is part of the planting program adjacent to the wetlands. So there will, we're not going to go in there and stop construction day one. I mean, so I would anticipate that restorative landscaping would already have included the plantings that are on that are shown on the plan. But the likelihood of this condition ever being implemented would be pretty slim.
Okay, thank you, Mr. Petrosi. So what I would recommend is that if we do approve this, we approve the requested modification with the additional part that that includes, if plants are required, then the security amount should include plantings and replant duyouts. So that would cover cover those concerns. Bob, do you think that covers it?
I do, yeah. You're on mute.
Sorry. In this condition, it's not what the applicant wants. It's what the applicant has, plus the additional comments from the conservation agent to require a restorative plan. And if plants are required, then it should include plantings and replanting duyouts. Could I have a motion to, well, let's just get it going. Could I have a motion to that effect?
So moved.
Okay. So now, any further discussion on this one?
Get a second. I'll second the motion.
Okay, sorry. Yeah.
Okay.
Okay, it's been seconded. Anybody from the public that wants to comment on this? So it's not just what the applicant wants, we're adding the comments from the conservation agent in how it will be worded. Okay. Okay, hearing none, it's been moved, seconded, and now we will we'll vote. This is on condition C2I. Roll call vote. Bob Fitzgerald.
Aye.
Suzanne Murphy.
Murphy, aye.
Drew Delaney.
Aye.
I'm John Lee, aye. Okay. Let's go to the next one. This is condition D1E, submit as-built plan of stormwater basin and infiltration units set forth in the Conservation Commission's order of condition for the project issued on November 4th, 2019. The peer reviewers' comments and recommendations submitted during the course of the public hearings and final approved stormwater management plans dated September 25th, 2019. That's the current condition. The requested modification is submit as-built plans of stormwater basin and infiltration units set forth in Mass DEP's superseding order of conditions for the project issued on February 20th. The peer reviewers' comments and recommendations submitted during the course of the public hearings and final approved stormwater management plans dated January 20th, 2020. The staff comment is, the conservation agent noted that the Conservation Commission included this special condition specifically so the infiltration basins could be reviewed after final grade and before going online. DEP's condition requiring an as-built plan gives no timeline other than prior to post-construction discharge. It has been our experience that infiltration basins need review earlier. And their recommendation is an as-built plan of the infiltration basins shall be provided to the Conservation Commission and reviewed by the town engineer no later than 30 days after completion of final grade. So
Can I make,
go ahead, Mr. Petrosi.
so I really don't have any objections to that wording, except that, you know, this is usually before you start any buildings or whatever, you have to build your detention basins first. And the purpose of an as-built plan is to make sure that what you've built is compliant with the plans. So if that wording is inserted, then final grading wouldn't be until sometime down the line when we're doing landscaping or things like that. So I don't really see that as a helpful word change, but I understand the need for an as-built plan before, let's say, building permits were issued or something along those lines. I just don't think, I think final grading is too far down the line.
Well, I think the conservation agent has a lot of experience dealing with this issue, and particularly in the town has quite a bit of experience. So as does the town engineer. So I actually think that the staff recommendation for the wording is stating an as-built plan no later than 30 days after completion of final grades. I think that covers the town, and it does not make this project difficult for you, Mr.
Oh, no, I agree. I mean, like I said, I'm not objecting to the proposal, just changing the proper plan and order of conditions, but I have no objections to that.
Okay. So are there any comments from the public at this time on this specific condition?
There is not.
Okay, so what I would recommend, and I think what we should do is we should, the requested modification should be what's been provided by the conservation agent and the engineering department, which is an as-built plan of the infiltration basins shall be provided to the Conservation Commission and reviewed by the town engineer no later than 30 days after completion of final grades. Do board members think that that's a good modification here? Okay. Could I have a motion to that effect, please?
So moved.
Okay, so that's what we're dealing with. Amy, will you note that that's what we're dealing with on this one?
Second.
Second by Bob, thank you. Any further discussion? Okay. So roll call vote. Bob Fitzgerald.
Aye.
Suzanne Murphy.
Murphy, aye.
Drew Delaney.
Aye.
I'm John Lee, aye. Okay, moving to condition number H9A. Applicant shall comply with all terms and conditions of the order of conditions for the project issued by the Conservation Commission on November 4th, 2019. No work may proceed pursuant to this comprehensive permit until all appeal periods have been exhausted and the order is recorded in the Norfolk Registry of Deeds. And it says here, numbering error from Wall Street Development. Yeah,
right.
What is that?
The requested modification is listed as number 8, and it really there should be no number next to it. It was a
Okay, right.
computer error.
Okay, so the requested modification by the applicant states, applicant shall comply with all terms and conditions of superseding order of conditions for the project issued by Mass DEP on February 20th, 2020. No work may proceed pursuant to the comprehensive permit until all periods have been exhausted and the order is recorded in the Norfolk Registry of Deeds. Staff comment says, see below. And the staff comment is from Landis Hershey, conservation agent, and she provides the additional comments regarding this request. The request for modifications are consistent with DEP superseding order of conditions, which is issued solely on the Wetland Protection Act and regulations. Because he references it in most of the modifications, however, I recommend the ZBA not remove the Conservation Commission's special conditions issued on 11/4/2019 from the 40B decision, other than the conditions the applicant objected to in his appeal. Special conditions number 24 talks about removing 30% organic materials only. 28, 46, 50, and 52. The orders of conditions apply to requirements of the Walpole Wetlands Protection Bylaw and regulations for the protection of the town wetland resources. I do not believe these conditions are in conflict with the DEP superseding order of conditions. So that's from Landis.
Right, and those conditions, Mr. Chairman, are in another section of the comprehensive permit decision.
Okay.
So we're not affecting those. We're not proposing to change any of those conditions.
Okay. Town Council, do you have any clarification on this?
No, not really. I just, that's exactly the type of thing I was talking about earlier, where a commission wants something preserved under their local bylaw decision because you're their last ability to have that jurisdiction, the local jurisdiction that gets subsumed into your process. So to the extent that needs to be clarified in that condition, then you should so clarify it. In other words, she's recommending what needs to be preserved from their local bylaw decision, which is not affected by the superseding order. And if you don't preserve it in your comprehensive permit, they're gone forever, the local bylaw conditions.
So, Town Council, why don't we just include in this modification request, I understand the need to put in the DEP superseding order of conditions. Why don't we also just include in the same line that we also reference the order of conditions from the Conservation Commission from November 4th, 2019?
They're already in the decision, Mr. Chairman.
I mean, I thought it was slightly different what the agent is saying. I thought she was just specifying what needed to be preserved.
Right. I think what she's saying is that there were certain of the local conditions that were the subject of the appeal to DEP, or the basis for them. And so it's because those items that she lists, 24, 28, 46, 50, and 52 were the subject of the appeal, that she's okay if we remove those, but she wants us to preserve everything else.
Right.
So
So,
if I formulated a motion, I would say, I move to approve the requested modification. However, we will note in the modification that all special conditions relating to under the local bylaw are retained with the exception of special condition 24, 28, 46, 50, and 52.
that's perfect.
Jesus, so moved.
You're muted, Mr. Chair.
Could I have somebody make that, forward that motion? Thank you, Suzanne, for forwarding Bob's motion. It's been made by Suzanne. We have a second on that?
Second.
Thank you, Drew. Second by Drew. Okay, any further discussion on this? And I do think, Bob, you're accomplishing exactly what Landis wants us to accomplish in condition H9A.
Who is that?
Okay. So any further discussion? No further discussion. Roll call vote. Bob Fitzgerald.
Aye.
Suzanne Murphy.
Murphy, aye.
Drew Delaney.
Aye.
I'm John Lee. Aye. Okay. Let's take a look at the next one. The next one is,
I think that was the last one, I think. There's a numbering issue.
This would be number 8.
Right. And under staff comment, there's number 9, but that's the staff comment to the prior request. So does that make sense?
Geez, I only have 6.
In other words, there is no number 8.
right.
Goes
Okay.
from,
Okay.
goes from 7 to 9.
Okay. So George, do we need to do anything else on this?
Yes, what I would end up doing is actually close the hearing and then schedule a night for deliberations. That the deliberations will be for the specific purpose of reviewing a decision consistent with your votes tonight. Pat, does that make sense, Pat? Or
Yeah, I was
Sorry.
just going to say we have a few comments from the public. I don't know if you want to address those, Mr. Chair.
John, you're on mute.
I thought the same thing, that we just addressed H9A, which we said there was the numbering problem was that 8 pops in there. So if you look at your sheet, H9A is what we just voted on, because we're taking them in order. And then we have H9B, which is, we didn't discuss this. And this is all terms and conditions of the order of condition are expressly incorporated. So we did not address this one. So I didn't think we did. And I want.
I think the last motion that we voted deals with the staff comment that applies to basically both 8 and 9, or
Yes.
what's numbered 8 and 9.
Right. And so, Bob, what we did was, it's actually,
Or whatever. Yeah.
yeah, I know the numbering is confusing, but let's just go with condition H9A. We just voted on that one with the modifications and the comments that Landis had. because her comment said, see below. And that's why we talked about it. Now we have to address condition H9B, where it talks about all conditions, all terms and conditions of the order of conditions issued by conservation are expressly incorporated as conditions to this comprehensive permit and shall remain enforceable conditions under the comprehensive permit, notwithstanding the result of any appeal. Should appeal of the order of conditions result in elimination or modifications of any conditions of order of conditions, and the applicant seeks to modify project based therein, any such modifications must be approved by the board in accordance with 760 CMR 560511. That was the condition. Now, the applicant has requested a modification, and it says all terms and conditions of the superseding order of conditions issued by Mass DEP on February 20th. And you guys can all read the same thing. I'm not going to read it, the whole thing. But what he's doing is he's requesting to replace the Conservation Commission's order of conditions with the DEP superseding order of conditions in this. And what we saw from Landis was she said, okay, but not these things that she wants to keep in there. So we should vote on this one also, because we did not vote on this one. We voted on A.
I think you're right.
Bob, do you agree?
Yeah, I think we should take another vote on this particular one.
Okay. So,
With the same verbiage as the last vote.
the same verbiage, including Landis's comments on this.
So moved.
Okay, so this is condition H9B, and yes, people at home caught that we did not vote on H9B. So could so Suzanne, you moved the motion to approve the requested modification with the comments from Landis Hershey, conservation agent.
Mhm.
So that's moved by Suzanne. Could we have a second?
We have a question from the public.
Okay, yep. Could we go ahead with your question?
Thank you, Mr. Chairman. Kathy Campbell. I appreciate Mr. Fitzgerald's explanation before about the plans that are filed with the HAC versus the plans with the DEP. So essentially, the comment where he's stating that he wants to replace the superseding order of conditions and the plans referenced dated January 20th, incorporated as conditions to the comprehensive permit. You're saying that ZBA has no jurisdiction over that decision, that those plans would be incorporated, and as long as those plans abide by the original plans that were approved, then everything is sort of copacetic. Is that what I understand?
Yes, that's what I understand it as. Bob, she mentioned you. Do you have any comment on that?
No, that's exactly right. And I think the last part of the language that was in the original condition and in the modification says that if there's any modification to our plans to modify the project based on the superseding order of conditions, any modifications have to be approved by the board. So that's where the applicant would have to come back to us if there's some inconsistency between the two.
Okay, and that's extremely helpful because I wasn't aware that both plans would essentially be in play through this approval process. And may I just ask a housekeeping question? There are some plans on the town website dated February 23rd, 2021, with a note saying ZBA conditions of approval. I'm not sure why they're there or how they got there, but they are significant. The buildings, there's decks and buildings that are significantly different than what we're talking about. So perhaps these need to be removed.
Well, Mr. Chairman, may I answer that, please?
Go ahead, Mr. Petrosi.
So in the comprehensive permit decision, the board requested that the final plans be submitted to the zoning board that included revisions cited by the peer reviewer. And some of those, and the board's conditions, which included location of utilities, location of walkways, decks, patios, things of those sort that weren't on the originally approved plans. So the February 23rd plans that were just recently submitted encompass basically all of the changes that have taken place since the comprehensive permit was issued and the superseding orders were issued and compliant with the comments by the peer reviewers that the board requested be added to the plan. So the February 23rd plans are going to probably be the final plans for this comprehensive permit, barring any appeal at HAC for the 32 units that were approved. So if for example, we would not be pursuing the appeals at HAC and we were to settle on the 32 unit approval under this comprehensive permit, then these would be the plans that would be constructed. So it's not that anything has to be eliminated. We've added everything that the board asked us to add to the plans.
This is, now I'm concerned that the zoning board issued a decision and then you've submitted like revised plans. I mean, town council, I need you to speak up on this one.
Yeah.
I mean, I don't have any opinion on it. I unless and until there's a modification sought for the approved plans, they're approved as per your original decision.
Can I interject for 1 second?
I mean, you have to be careful about is this latest one asking that you only preserve the superseding order in your order? Or is it asking that you preserve you preserve all the conditions in the original order of conditions except for a finite number of them that are modified?
Okay. So, George, you're talking about what's right before us. What Mrs. Campbell's saying is that there's a set of plans that's out there, and I want to let Amy address that because Amy's the one who posted it. Amy, go ahead.
Yes, so I'm on the website right now. The plans that Kathy's talking about are under the border that says comprehensive permit materials for approved permit. And then it says in stars that it's the remaining documents required to be submitted prior to commencing construction according to the above comprehensive permit that was approved. So these aren't approved plans. They're just submitted for the comprehensive permit that has been approved. Does that make sense?
I think, Mr. Chairman, I don't want to confuse the thing, but I think town council should spend review the comprehensive permit, and in the comprehensive permit, you'll see that there's a condition in there that the board required of Wall Street to submit final plans to the board showing these various things: sidewalks, walkways, driveways, utilities, patios, decks. You required of us to do that. We did that. So now someone should have been reviewing that, and I don't know if they did or they didn't, but that's really what was required of us, of the board. Forget about all these other these other requests. Forget about those. If we just
we're getting off topic. We're getting off topic. But the fact is that I'm concerned that the zoning board of appeals approved a project based on a set of plans. And what we did was we said, well, we need a set of plans showing all these modifications that we want. And then we had to come in, and that's what Mrs. Campbell's talking about now, is that is the plan that's been submitted. And it probably doesn't look exactly like what the zoning board had in front of us during the public hearings.
No, it does, other than the additional minor details that you've requested, which
Okay,
are,
well, we're gonna go through it. So, Mrs. Campbell, I understand where you're coming from on this.
I think you should read that condition that's in the decision.
Yeah.
We're just trying to comply with the decision, that's all we're doing. So,
I'm lost. I don't know what I'm supposed to review, or I don't post things on the town website, and I don't care what's on the website. I care about what you approved and what's before you for a modification. So I'm not checking any website, and I'm not rereading anything. So let me be clear to the applicant. So if you're submitting stuff and you think it complies, good luck to you, but that's not part of this.
Right.
I think you should read your decision, that's all.
No, I don't need to read anything. I just need to read the modifications that are before the committee.
Okay.
That's right. And that's what we're dealing with tonight. That's what we're dealing with tonight. And, okay. And things that get submitted to the zoning board and they get posted on the website, that is not part of what was part of the public hearing process. You know, what you're saying is that you've submitted a final set of plans and those will be reviewed, but the plans that we're working off of what was submitted and what we had the public hearings over, that's and that's what was approved.
Yeah, and there's not going to be anything being reviewed under the permit until the appeals are resolved on the permit, okay? So I'm talking directly to the applicant with respect, Mr. Chair. So you've got your appeals pending, and those will be brought to a conclusion before anybody does any review or applies any of the conditions under the permit. Right now, you've got pending appeals. So you don't have an operative permit that you're entitled to be submitting anything pursuant to. So if you want to drop your appeals, we'll start reviewing your submissions.
Okay.
Okay, thank you, Town Council. So we're at H9B, similar modifications, and it's already been, the motion's been made, it's been seconded. Mrs. Campbell had her comments, which really didn't apply to H9B, but I think it's appropriate that she brought it up, but it's really not what we're talking about with H9B here. Mrs. Campbell, do you have any other questions or comments?
No, thank you, Mr. Chairman. I understand.
Okay, thank you. Okay, so H9B with the comments from Landis Hershey is what we're voting on. Board members, any questions on this? Okay, roll call vote. Bob Fitzgerald.
Aye.
Suzanne Murphy.
Murphy, aye.
Drew Delaney.
Aye.
I'm John Lee, aye. Okay, so those are approved, and with the modifications and the comments from the town boards, across all those. So a decision will be drafted. Patrick, you'll work on that. Amy, you've got some of the minutes for this, and then we'll review it at a, George, we have 40 days to get this filed. Is that correct?
Well, I would go ahead and, I would recommend you go ahead and formally close the public hearing.
Okay.
And then discuss next steps after you close the public hearing.
Okay, thank you for that. Okay, could I have a motion to close this public hearing, which is case number 0519-02?
John, do we want to check with the public one last time before we close, maybe?
Okay, yeah.
Just asking.
Yeah, no, I think that's only fair. Are there any comments from the public at this time, just as we close this? And all we do, this hearing was only to address those 8 issues that the applicant had appealed.
There's no hands raised.
Okay. Okay. So
So moved then.
moved by Suzanne to close the public hearing. Second.
Second.
Second by Bob. Any further discussion on closing case number 0519-02? Okay. Roll call vote. Bob Fitzgerald,
Aye.
Drew Delaney,
Aye.
Dan Murphy.
Murphy, aye.
And I'm John Lee, aye. The case is closed. And now, George, to schedule time to, what do we need to formally vote on these, or how, on the decision, or how are you recommending that we proceed with that?
Yeah, I would schedule deliberations for review of a decision consistent with your vote during the public hearing. And then you can take your final vote issuing the decision at that deliberation session.
Okay. Okay. And we have how many days to do that?
40 days.
40 days, and that's under 40B that we have 40 days?
Correct.
Okay. Okay. Very good. So let's, Patrick, how long do you think you'll need to draft this decision and have it over to town council so that they can review it? And
I can have that ready by next week. And if Attorney Pucci would like to review over sometime around the 12th or the 13th, get it ready for the 19th.
okay. George, does that sound reasonable to you?
Yeah, I mean, I can review it the same day Patrick sends it to me, I'm sure.
Okay.
No matter what I have on, I'll be able to get it back to him.
Okay. Okay. And Amy, do we have a meeting on the 19th?
So the only item we have for the 19th right now is Moose Hill.
Okay. Okay, so let's put this on for the 19th, and we can address those issues. Okay. Okay, any other questions? Just we've have a motion to close the hearing, and now it's scheduled. It's closed, and now we just have to it's scheduled.
Issue the decision within 40 days, and you'll do that at those deliberations.
Okay. Thank you. Okay, next case. Does anybody have anything else before we go to our next case? Okay.
Did we vote for the May 19th?
I don't think we need to. We just need to put it on the agenda. The case is closed, I think.
Yeah,
So I don't see that we need to vote on anything. Suzanne, do you agree with that?
Yeah, no vote on that. We just
Okay.
set
But
another
we need
deliberation date.
Yeah, on the agenda for a deliberation and likely vote. Okay, next is case number 0520 Wall Street Development Corporation, Dupuy Street, comprehensive permit pursuant to Mass General Laws 40B, as amended to allow construction of, originally it was 12 duplex condominiums and 6 buildings, but the plan has been revised. And now what we're doing is we're doing the list of waivers. So list of waivers was sent out to everybody.
Yep.
Pull that up. Okay, thank you. Amy, I assume you're the one that pulled that up, list of waivers.
That's me, Mr. Chairman.
Oh, okay, thank you, Patrick. Okay.
Mr. Chairman, if I may, after the previous public hearing regarding this, I reached out to Mr. Petrucci of Wall Street Development to go over some of the concerns we had last time regarding just the clarity of what was actually before us. So that this revised list that you see before you should be consistent both with what Mr. Petrucci actually is seeking a waiver for. I know that was kind of just a point of clarity at last time we met regarding Dupuy Street. So we just want to revise that issue.
Okay. Okay, so the way we've done this in the past, if board members recall, we go through the waivers and we say whether we agree with them or not. And so we go right down the list of waivers. Town council, do you have any guidance for us as we move forward on this?
Nope, that would pretty much be the way to do it, one by one.
Okay. Okay, so let's go right down the list of waivers. And Amy, are you able to edit this as we go down? I'm sorry, Patrick, are you able to edit this as we go down?
Yes.
Okay, good. So the first one, the waiver request is, it's a waiver from section 2 of the zoning bylaws. I'm pulling. So that is all the administrative sections. Seems rather broad, Mr. Petrosi. What's going on here?
I don't think it's broad. It's just one section of your zoning bylaws, regarding applications and fees and other things, I guess. I don't remember, quite honestly.
So, Mr. Chair, this is regards to following Chapter 40A, whereas this project being a Chapter 40B, that seems to be why the applicant is requesting a waiver.
Usually, Patrick, the applicant goes through these, usually.
Okay.
Thank you, though.
Okay, so it's requesting because it's a 40B, it is asking to waive the 48 regulations. Seems rather broad and encompassing, where the whole idea would be that we go through the individual waiver request. So,
Well, why don't we move on to the next one and set that aside till the end, and then.
okay, well, let's put a no on this one. This one's
And John, you can also always indicate too, not applicable or not required.
okay.
You know,
Okay, let's go to the next one. Recreation and open space. Detailed
Well-
listing. Yeah, go ahead.
So as the board knows, this is a small site. It's very close to the Old Post Road School and the Bird Middle School and the Bird Park, all within walking distance. So we request a waiver from the open space requirement.
Okay, board members, any comments or thoughts on that?
Yeah, Mr. Chairman, I think the requirement is just to provide a list of those things that are being provided on the project site. And
Right.
if the answer is none, then that's the answer. I don't know that we I don't think we can waive this just because there's open space nearby. I think that we're just looking for a listing of what's being proposed on the site with respect to open space. And the answer to that could be nothing, but that's all that it's asking for.
Correct.
So what, not applicable? Is that what you're recommending, Bob, on this? So what do you think, saying?
Well, I mean, I think what I'm hearing from the applicant is that there isn't anything being provided on site because of the proximity of these other places. And so basically the answer to the request is that there's nothing to be listed on the site in terms of open space and open space amenities.
I don't think he said because of the closeness to these areas. I think he said because it's a tiny site.
Well, you're right, whatever the justification, I guess the question really is, are you providing any open space amenities or not? And if the answer is not, then the request is just for a list of things. It's not for set aside a certain amount of open space
Right.
or do so many square feet of this. It's just a list. And if the list is doesn't include anything, that's something we'd like to know, but that shouldn't be too hard to provide, I guess.
That was my fault. I completely misinterpreted the provision.
So let's just say none provided, but just, he didn't provide a list.
No, it's a different issue, John. It's basically you're denying the waiver. You're requiring the list, and he can respond by providing a list saying none. That's what Bob's saying, is that you're not waiving the requirement to provide the list, and he's free to list whatever he wants, but you're not going to waive the provision.
Okay, you could waive.
That doesn't mean that you're
list.
requiring, that doesn't mean you're requiring on-site amenities. It's just requiring him to provide a list of what he's doing, what he's proposing.
And town council, that list could say, I'm not doing anything. Is that correct?
Right.
Okay. So he hasn't provided us anything. So as far as a waiver, how do we grant a waiver if he hasn't provided anything?
You don't, you deny the
We don't.
waiver.
Right, we don't.
Okay, so no, deny, okay. Pro forma. Okay, applicant requests waiver from regulations they believe in excess. Doesn't want to provide a pro forma, so
Do you want my comment on that?
I think.
Yeah, I do, please.
Yeah, I mean,
Well-
I think that there's a point to be made about requiring that as a general matter. I agree, you don't have the authority to impose that. And it's up to you. If I didn't hear any dialogue during the public hearing that any particular condition that you're requiring is rendering his project uneconomic. So I'm not seeing a basis for requiring a pro forma here. So as far as I'm concerned, it wouldn't be unreasonable to grant that waiver.
well, that always bugged me because we can't do something that would make the project uneconomic, but we don't have any idea what the economics of the project is. So
It's a very frustrating part of this process. It's true, because it's set up against you that you're not really allowed to delve into it because of all the time wasted during this public hearing with a lot of unnecessary unanswered questions all the way along. You've never really gotten into a substantive discussion about conditions or how you'd like to condition it, and if that would render it uneconomic or anything like that. So this is your typical, it seems to be a pattern. So you're being forced into, ending up issuing a decision on this without a real good faith, substantive dialogue or offer of legitimate information in support of the project, as far as, in my opinion. So you're stuck with that, you'll have to guess at whether your conditions allegedly render the project uneconomic, and the applicant will save that for an HAC appeal, I guess, is the reasoning behind that. So, but the fact is, you unfortunately, you cannot, as a matter of course, require a pro forma.
okay, so you just said, as a matter of course, we cannot require a pro forma. So on this, do we have to approve this?
No, you're free to
Okay.
grant it or deny it however you want.
Yeah, well,
Like I say, you've never gotten into the dialogue about,
No.
you've never said, well, why can't you do X, Y, Z on the site? And wouldn't this be a better project? And here's what the design architect says, and here's what the site engineer has found, and here's what the neighbors are reporting, how they would like it to fit more into the existing neighborhood. And you've never had that substantive dialogue with the applicant because the way the applicant presented this application is, you know, whether it's purposeful or not, it's in a sort of hodgepodge way so that you're just left to sort of guess at it and condition it yourself. So you've never had that dialogue where he comes back to you and can say, you know, please don't do that to my project because it would render it uneconomic. You've never, and if you're having that type of substantive dialogue during the public hearing, then at that point you could request a pro forma and say, well, show us the pro forma for the project and what exactly you need on this site, and then we'll try to condition it accordingly. You're not able to have that dialogue with him because you're left on the eve of the close of the public hearing, and you know, you have the state of the information that's before you on it.
Mr. Chairman, I take offense to that because we've changed the project. We haven't asked for anything. We've addressed every comment that's been made by all the departments. I don't see where there was a need for a dialogue. We didn't challenge anybody's jurisdiction or comments. We did everything that was asked of us. I don't know where town council's coming off with those comments.
Okay, so town council.
The record speaks for itself is where I'm coming from, the comments, including the last time the design architect for the board was present at the hearing. He listed a whole bunch of things that he'd like to know, and he knows darn well he's not going to get them. And the neighborhood has reported several instances of issues that they would like to see addressed that are just not addressed. So it is what it is. The record speaks for itself. I've given my opinion about the pro forma, and you can take it from there. And Mr. Chair, I'm not posing any questions to the applicant, so you don't need to allow any sort of dialogue between the applicant and council.
Okay.
And I suggest you just mute him if unless you want comment from him.
You know what? So Amy, please put there. Thank you. And if we need comment from the applicant, we can get a comment from the applicant. Okay. So
I don't want to waive this. I think we should just wait and not waive it. If we need one, we can. I just don't feel comfortable.
I think I hear what you're saying, Suzanne, and I agree. We're kind of in a bind, right? We don't know what the performer is going to say, but I think what town council is saying is that the way that 40B works is you review the materials and either hopefully you can discuss conditions before the close of the hearing, but if you can't, then we impose conditions as we think appropriate. And if that makes it uneconomic, then they can appeal. But until the applicant, it's sort of up to the applicant whether to kind of open the door to this type of information. And if they choose not to say, hey, that's making my project uneconomic, then we can't ask them for the pro forma. But once they do make that assertion in the hearing, then it's like, okay, well, now you have to back it up with your pro forma. So to this point, I don't think the applicant has made any arguments that any of the conditions that have been discussed or, the revisions to the plans are making it uneconomic. So I don't think we can force the pro forma out of them at this point.
Okay.
That's my understanding of things.
All right.
So I guess I would propose that we do waive this, assuming we're going to close the hearing tonight since we have to before tomorrow.
So my thing is, the applicant has not provided a pro forma. We're trying to provide affordable housing in our community, but we don't know what the point is where it becomes uneconomic for the applicant. So without a pro forma, how can we tell any of this information? I guess that's where I'm coming down on this.
I think we assume that it's not making it uneconomic until he tells us it is, and then we get into the nitty gritty of the economics of it. But until we get that kind of feedback from the applicant,
so if
there's no evidence in the record that it's uneconomic.
So if the board were to approve this and the applicant appeals, at that point, can we then expect to see a pro forma? I'd rather protect our rights to be able to see a pro forma by stating that we don't deny it. Because if we were to approve this 8-unit plan, and we don't ask for a pro forma now, we're never going to see one.
That's true, but I think unfortunately, that's the hand we're dealt under 40B.
Well,
And we
for that-
can't,
That reason.
Yeah, John, I should note that that's the way Bob is describing it is exactly right. And that was the point I was making before, is that you never ended up being able to have any type of substantive dialogue that, the applicant would make that claim, you're rendering it uneconomic, and then you say, well, show us the pro forma and we'll try to work with you from there. It is a hide the ball type of thing. It's a squeeze play, basically. And the only time you'll see a pro forma is in the event the applicant is unhappy. In the event of an approval with conditions and he's unhappy with your conditions, he'll appeal the HAC. He needs to, it'll be his burden of proof to prove first that the conditions, either singly or in the aggregate, render his project uneconomic. So at that stage in the proceeding, he will have to produce a pro forma in support of that at the HAC stage. At that point, if you're defending it, unfortunately, at that point, then the town has to go ahead and hire an expert to review the pro forma, as opposed to, having the dialogue in the public hearing. So it's an unfortunate way it's set up. And it's an unfortunate way, that this application was presented, that you never had really a substantive back and forth about really what makes most sense for this site. That's to have a site plan review that's within your purview, and to talk to him about legitimate issues and have him prove to you that, no, I can't build that project. It's uneconomic if you condition it that way. It would have been preferable to have that type of dialogue in the public hearing, in which case you would have seen a pro forma in the public hearing if you couldn't, reach agreement about, site plan review issues. So unfortunately, you're not going to be able to have that dialogue in the public hearing, but eventually, in the event of appeal, a pro forma will have to be produced regardless of whether you apply this regulation in the public hearing or not.
So let me just ask you, George, we just sat through an hour and 45 minutes or more of Burns Ave appeal and things like that. No pro forma's been, and he's appealing the specific decisions that we already issued. No pro forma was provided there. Why'd we go through that whole crazy exercise?
We have not even gotten in the stage of those HAC appeals have been just tied up in, pointless procedural issues. And we haven't even gotten into the substantive basis for the appeal. So we're not even at the stage where, the parties have identified evidence or anything like that would come out of the adjudicatory hearing. That's still, preliminary stage at the HAC. So, you haven't seen them there yet either, but it'll be his burden in those HAC appeals as well to prove that the conditions render the project uneconomic. That's with regard to the initial approval with conditions. The peer review issue is a totally different type of issue. So I don't know what exercise you're talking about having gone through, but
well,
an awful lot of time is spent on just seemingly non-substantive issues. It just seems to be the case with this applicant.
Yes.
Just is what it is.
Could I propose something else just to see if this would facilitate things? If we chose not to grant this waiver, we're still okay if we don't, and we don't get into a substantive discussion of economics, then so long as we don't deny on that basis, we would be okay, right?
I'm okay with that, right?
Yeah. So,
yep.
So we can not grant the waiver, but we can't deny this permit on the basis that he didn't provide a pro forma.
Correct. I totally agree with that, but I want to keep our options open that we expect to pro forma. and I think that's reasonable. So on this, I would, do board members feel comfortable saying deny for this? Doesn't mean that we're gonna, deny the whole project, but this particular request, he's asking to be waived from the performer. I think we need to have a performer to understand what is gonna make this project uneconomic. Bob, do you agree with that?
Okay. Yeah, I'm fine with that.
So Patrick, would you put in deny on that? Thank you. Okay, going down. This is so unprofessionally done. Normally, okay, we'll after this one here, subdivision. He's claiming it's not a subdivision. So he just wants blanket waiver for that. Suzanne, you've done a lot of subdivisions. What do you?
No, this is like reading another language or something. I'm referring to the extent that each regulation I don't know. I'm gonna need George or Bob again.
There's a difference between needing a waiver and something not applying. So, I mean, you can think of the universe of laws and multiply this by, a trillion fold about all the things that aren't going to be required, but they're not relevant. So is there a subdivision of land proposed or not? No. Then obviously you're not going to apply subdivision rules and regulations. If there were a subdivision proposed, then they would have to comply with the state subdivision control law. So, and sometimes you'll take standards. You'll take a particular standard and you'll say, well, we want this particular standard with respect to roadway pavement. And we get that, from our subdivision regulations. That type of thing is a legitimate dialogue. Then you're looking at it because even though a subdivision is not proposed, there was a rational basis how you came up with whatever local regulation you had with regard to pavement thickness or something like that, or sidewalks, or, some type of material. So sometimes you'll incorporate, a standard that's in another regulation. But that's not the situation here. And to be talking about a blanket waiver of, rules and regulations that most likely do not apply to this project is pointless. So it's another not applicable, as far as I'm concerned, subject to further discussion about which of those regulations does he think you intend to apply to his project?
George, would this include any safety regulations with fire and police?
I don't know. I can't answer that in the abstract. It's not, you can't impose local regulations with regard to subdivision if there's no subdivision, proposed. So the only issue comes up is, as I've said, if there's some type of standard in there that is applicable to this project that you like the way it's worded and there's a rational basis and it applies here, then you would specify that. But, I'm not aware of anything like that would apply to this project. Have you received the input from everyone? The, town engineer, the building commissioner, everyone with fire, everyone with respect to proposed conditions or regulations that should apply? That's really what you have to go by. But it's very unhelpful to be providing these blanket waiver requests of, again, a body of regulations that probably don't apply to the project. So it leaves you to guess, I guess, basically, unless you pull it out and you go through it one by one, he's leaving it to you to guess and act at your peril that there might be something in there that you might have wanted to apply.
Right. I agree, George. And it should be specific waivers
Right.
for the construction of this project. And to just have, all subdivision of land, as amended through 2016, that's not identifying the specific waivers. So again, I'll say on this one, deny.
Yeah.
We can't just give an overriding waiver to everything. Okay. The next one start getting into more detail, but I'm actually having a problem with some of these. So let's go to the. Well, I've actually got my trusty old copy of the zoning bylaws here, and 5B3D. I'm having a problem finding this. This specific number. 5B3.
Yeah, I don't think that's,
That's an incorrect one, isn't it, Bob?
doesn't point to the correct,
When I look up 5B3, I'm coming up with accessory in-law suite. Are you coming up with the same thing, Bob?
3D.
No, that's the-
So 5B, 5-B is the table. Or the schedule of use regulations. And so then if you go into the table, item 1 is public, semi-public, institutional. Item 3 is residential. And then subsection D is dwelling for occupancy by more than 3 families, provided that, and then a 50-foot item. Romanet 4 is if there is to be more than one principal building on a lot, there shall be a minimum of 10,000 square feet. So but 3D deals with dwelling or for occupancy by more than 3 families. And it's my understanding the application is for 8 single family dwellings. There are no multifamily dwellings on this project. So I don't think that this particular provision that he's pointing to applies to the project.
Yeah, so you are correct that the small d on this is, as you said, for more than 3 families, for dwellings for occupancy of more than 3 families. And these are single family homes that are being proposed. So
correct. So I think we say not applicable.
well, I think not applicable.
No.
Wrong. Yeah, wrong reference. Not applicable. Wrong reference.
Not applicable because not multifamily. No multifamily proposed.
But doesn't he need to come up with a new waiver then?
If he doesn't, and he needs it, then that's a problem for him.
Okay.
John, maybe you should be specifying on not applicable, it's maybe denied as not
Yeah.
applicable. And on the blanket one, instead of just denying it, denied, pending further specification with some of them. So this one, the one that it's anybody's guess why he put it on here, but if it's not applicable, maybe denied as not applicable.
Okay.
And that leaves him free if there was some mistake, if he needs to come back or whatever. Denied as not applicable. And then the other one, the subdivision rules should be, denied subject to further clarification of specific waivers sought.
And, okay, and Patrick, on this one that you have right there, denied, not applicable, it's not a reference, these are single families, not multifamily. So. Okay. Okay, next one. Section 5D, excavation or filling of earth.
Generally not in favor of granting this waiver because it allows the site to be cleared even before a building permit is issued. And, you know, the plans approved in the comprehensive permit, you know, are not really construction ready. So there could be issues that come up down the line. And then in the event that for whatever reason, the project doesn't go forward for financing or other reasons, I'd hate to have a clear-cut site and no project. So I'd propose to deny.
Agreed.
Agreed.
Okay. 5D 3E. This is activities approved as part of any site plan review. Actually, site plan review is not required. I probably agree with this.
Five D.
5D 3E. So it's just as it says in the bylaw, activities approved as part of site plan review application. We're not doing a site plan, we're doing a comprehensive permit.
So
Right.
it's denied, not applicable.
Well,
Is that correct?
section 13 of the bylaw, you know, lays out site plan review for various projects. And I don't know that site plan review is not applicable and that we're not responsible for. I'm just checking to see its applicability. Multiple
This is
building.
all excavation. This is excavation stuff.
Right.
I think once again, we have to wait for a permit, no?
I mean, go ahead.
I was just going to mention, so being that the project is a 40B project, it's doesn't usually fall under the same guidelines as local regulations for site plan review. So I would imagine the request would either be not applicable or however, which way you want to go.
Yeah, I would agree with that. It's another not applicable.
Right.
Okay, and town council, is it not applicable because we're doing a comprehensive permit, not a site plan review?
Right.
Or does the zoning board sit for other boards and do site plan review as the comprehensive permit? That's because I look at what a site plan review is, and we've done every bit of a site plan review
Yeah,
on this.
maybe denied is not applicable, subject to further clarification.
Yeah.
Could be
Yeah.
the answer to a lot of these.
Agreed.
I mean, I could go through these with Patrick and we could do a document for you for deliberations if you want. You could run through them then, unless you think you're going to need input from the applicant or anybody on these.
No, I want to go through it tonight for the board.
Okay.
And
I mean, you would have,
sorry
you would-
if
yeah,
this is-
no, you would still have the opportunity to do that. I'm not saying that you wouldn't still go through them, but you know, but go ahead. I didn't mean to interrupt. I'm just trying to, you know, figure out a way of doing it other than needles in the eye and figuring out each one. And most of them are inapplicable.
needles in the eye is sort of the way this has been going. So I do think it's important because we're going to close the hearing tonight, I think. And I want to also document that, you know, unless the applicant wants to continue, we need to get these things further clarified. But
Right.
I want to
Right.
go through that. I want to go through that tonight. So next
Thank
one,
you.
5D4A. Activities requiring a special permit.
This is the same one where he could clear cut and then we don't know.
Well, this one involves activities associated with residential use that involve excavation and filling 100 cubic yards of earth or more per year.
I mean, I think this is another where, like, you know, he doesn't need to get the special permit per se, but he needs to say how many cubic yards he estimates he's gonna. It's hard to evaluate the scope of the waiver we're granting when it's just,
Right.
it's gonna be over 100 cubic yards, but is that, you know,
Okay,
1,000 cubic yards? Is it a million? I don't, you know.
Usually it's
I-
like, yeah, usually
I
it's more
could-
specific.
I would suggest just, you know, that waive requirement of special permit, you know, otherwise denied or otherwise subject to further conditions. Do that type of thing. Obviously, you're not going to require a special permit. You can't do that. You're under the 40B. So maybe just, waive requirement of special permit or special permit requirement not applicable. The rest of it's denied, you know, subject to further conditions.
Just like George said.
It's up to you, John. I just, you're not gonna, a special permit is not required. So it's not so much that you're waiving it as much as it's not required.
okay. Okay, and just one of the things that was brought up in the hearing, I asked if this was a balanced site for excavation, and I was told it was a balanced site, meaning nothing coming on, nothing coming off. So it's surprising that this is a waiver that's being requested. Okay, next one, 6B, 1C. This involves rear line setback. Oh, no, there's a street line setback. So I'll just speak on this. One of the things, I don't think we'd ever win on this on 40B because part of it is that they seeking to be exempt from local zoning bylaws. And this involves the setbacks, it's a dense, increasing the density. That's what he's shown. And we've had a lot of discussion about particularly the rear yard. And the only one that he's requesting a rear yard setback for is building number 7, which would be at 19 feet. Other board members, what's your thoughts on this?
Yeah, I mean, I agree. I don't know if we want to, I don't know where the board is on the density of this project. I mean, we really haven't discussed whether we think 8 is the right number or not. But so I guess in that sense, to the extent that's going to be a discussion, which I don't know if it will be in deliberations, maybe we just, do we have to specify specific buildings or? Anyway, I guess I don't want to back into 8. If the board's comfortable with 8, then maybe it's not an issue. But I haven't heard a lot of discussion about that.
I'm not comfortable with 8, but the fact is that it's a 40B, so it's going to be a multiple of 4, and you know, I don't know.
Yeah, no, that's I didn't want to. I don't want to throw a wrench into the discussion. I just was thinking if there's a way we could just describe. Yeah, we're going to grant setbacks for the approved, as requested for the approved buildings or something like that. I don't know. I guess there's actually another. Another waiver, I think, for the number of principal buildings. So I'll withdraw that comment, and we can discuss that issue at a different waiver. So I'm okay with this one.
Is that correct?
I'm okay with that. Other board members?
Yeah.
I think we're doing it again in the next page, right?
I think it appears in 2 different spots in the bylaw, so I think that's why it's been requested
So
twice.
let's attack the second one because that's got more detail and put not applicable for that one. Because I think they're going after the same thing. It's just in 2 different, they just doubled up or something. Yeah, it's the exact same thing.
Okay, so you want non-applicable for the first one, and then you would want to go into the table.
Yeah, because then the next
Okay.
one gets a little impervious is included in that, so. Is that okay with you guys?
Yeah, that works for me. That section makes reference to the table, I think,
Right.
anyway. So it's kind of
Right, so it's
So
better,
we're-
yeah.
yeah.
So would the table for 6B1 be therefore granted?
Oh, we haven't
Based
turned the
upon-
page yet.
Okay, sorry.
Just realizing they're doubled
Ah,
so far. So is he asking for a waiver for impervious here?
Yes.
Yeah, to go
Okay.
from 25 to 28%,
And from 40 to 46?
right? mean, just a point of, I guess, procedurally. So we're going through this list and we're sort of indicating we're going to grant this, or we might, or we don't grant that. But at the end of the day, when we deliberate over a decision, we'll have to modify whatever waivers we're granting to be consistent with whatever that decision is. So if I'm understanding that correctly, then we're sort of indicating tonight that we're inclined to grant this, but, you know, subject to our final deliberations kind of thing. Does that make sense?
Well, yeah, this is the first step in the process. But one of the problems with this is that there's a whole bunch of waivers in one section. And really what it should be is there should be a request for waiver from lot area required. Next one, waiver from impervious surfaces. Next, you know, these should all be broken out to have them as just, you know, the whole group of waivers is, it's not helpful, because even we're getting into individual buildings where one building has a setback of 6 feet, and you know, the other buildings have 25 feet.
Right.
And even building 7 is out of this altogether. If you read this, if everybody would, buildings 1 through 6 have a minimum street line setback of 25 feet. And then building, but it doesn't say.
Doesn't say what 7's doing.
Well, it says 7 is going to be at 19 feet, but.
But that's rear yard, rear.
Right. So, or is it saying that 7's going to comply with it? So.
Right. So the waiver wouldn't be granted for 7 and 8, just for 1 through 6.
Right.
Yeah, I agree with that. This could be like one of those brain things that the old people have to do when they get old. Instead of doing like crossword puzzles, you could read this kind of stuff to make sure you're not getting dementia.
Mr. Chairman.
Yes, Patrick.
So I just want to kind of, this is something that Mr. Fitzgerald mentioned, that these waivers are kind of looking into the most recent revision of the site plan. So if the board felt that the waiver was applicable, it may be subject to final approval of the site plan itself. Rather than granting the waiver beforehand, wait until the subject review, subject to the actual final approval of the final revised site plan.
Yeah, because I think we're going to vote the waivers at the same time we vote the decision. So the decision will include as an exhibit the waiver. Rather than voting the waivers tonight, we're just kind of going through them to, give everybody a sense for where we are on them. At least that's my take.
And that's typically what you try to do is you try to look at the plan, deliberate, decide what it is, if you're going to approve it, as opposed to a denial. If you're going to approve it, what exactly are you approving? The buildings and how many and what size they are. And then you kind of back into the waivers that way with specifics. Okay, what waivers do they need from our local requirements to allow this basic plan to be built? And then you put the specifics down with respect to that, and then specify, to the extent not specifically granted, that waivers are denied or all local regulations shall otherwise apply. And to the extent there's an inconsistency with the approved plan and the specifics with regard to specific waivers granted shall control. In other words, you're not, the fact that you're approving a plan that may call for a waiver that you didn't specify, doesn't mean that that waiver is granted. So that's where the specifics really come in, because that's where you're starting out and then backing away from it. So it's difficult with them, being all thrown in like that. But that's right. You're typically tying the grants of a waiver to your site plan review, to what basically you're allowing to occur at the site. And then, hopefully the applicant was helping you specify, the specific local requirements that they need waived to allow that plan to go forward.
Okay, so what do people want to do on this one here? It's asking for basically the whole waiver of table 6B1, which I'm not sure that's the way it should be done. It should be asking each item.
Building, right.
Well, if there's each building, but rear yard setback, ask for the waiver for which building, but to put it all into one section is not helpful.
Like, I don't know what the rear yard is for buildings 1 through 6.
Well, that's a good point, Suzanne. Based on this, I'd make the assumption that buildings 1 through 6 are not requesting a rear yard setback.
So then they're 30 feet.
That's what they, yes.
Okay. And so then building 8, the rear yard would also be 30 feet. Because it's not asking for a rear yard waiver, correct?
Right. And I'm going to
Okay.
try to pull up the plans.
And building 7 would have a front yard of 30, because it's not asking for a front yard.
And we could say that we're inclined, to grant dimensional waivers subject to approval of a final site plan. It's like everybody's pointing out, it's hard to know.
I'm pulling up the actual site plan now. And the applicant is showing that the setbacks are 30 feet from the line on
1 through 6.
1 through 6. So,
But the deck is there.
right? Okay, so yeah, somebody else brought it up. I'm looking at the same thing. And 19 feet for unit 7 as stated.
But that's the side yard on unit 7. Which 20 is required,
Right.
right?
Yep, and it's saying that the side yard setback on unit 7 is requesting it actually says rear yard setback of 19, but it should be, you are correct, Suzanne.
Sideline.
Well,
Unless
I-
it's rear yard of the site, I don't know.
It's the rear yard of the site, so I think that's why, because it's all one lot.
Okay.
And so that was something I did confirm with Commissioner Yanovich.
Okay.
All right, so it's we're flipping the building now? I mean, I'm a corner lot. I have to deal with a lot where I live. All right, so we're using the rear as the side right now?
Yeah, because it's the lot. So,
Okay.
yeah.
Okay, so the side where the woods are is 40 something with the deck. And that's okay. So building 7 is kind of legit. We're not asking for any waivers for in between the buildings?
So
It's a
Suzanne,
separate waiver.
yeah, that'll be a separate waiver. Yeah.
Okay, so that must be coming up.
Those
Okay,
are all 11.
right.
11
Okay.
The state fire code is 10 feet, I believe. Okay, so on these, you know what, it looks like what's being presented here, the list of waivers, it appears to me right now to be consistent with the plan that has been, given to us. Do people agree with that?
Is building 8 allowed to be 6 feet from the street?
Well,
There's
under traditional zoning, no, but obviously I guess that's why he's.
No, but I mean, there's no waiver, building 8. Yeah, oh, it does say
Yeah.
6, okay.
Yep.
All right, so they got one right. Oh, they got 2 right. Woo-hoo.
So, Mr. Chairman, do we want to have this be subject to final approval?
Yeah, I'm actually okay with these. It's very sloppily done, but I'm okay with it.
All right. I'm not all right with the 6.
The 6. So, okay, from the roadway there,
Yeah, that's pretty darn close.
it's not going to be it's not going to be an actual road there,
Right.
Suzanne.
Right.
But it is, I guess, who knows, in the future, it could be a road, so. Because it is, if somebody, yeah, that'd be interesting if one of the residents on over on Civil Street decides to make access to their property through the back here, they'd probably have every right to do it.
Yep.
But that's.
All right, are we moving to 6C?
Let's go to 6C4, not more than one principal building constructed as a dwelling on one lot, on a lot. This whole
So-
project is predicated on 8 on the lot.
So, Mr. Chairman, so this was something that I actually, for both 6C4, A3, 4, and 6, there was a little bit confusion because if you look in the zoning bylaws, there is no 6C4, A3, 4, and 6. The reason being is that I believe in the Springtown meeting of 2018, this is where an article, its original motion included additional subsections that had more defined requirements, which are noted in the waivers. However, a subsequent motion changed that bylaw amendment to the language that's in there currently. If you're looking at your zoning bylaws that are revised through May, I think it was May something of 2019, May 6th.
May 6th.
May 6th. So what's within the bylaws is actually accurate. And so initially when I had spoken to Mr. Petrosi, there was some kind of confusion whether or not what the actual subsequent motion was. And so I had a conversation with the town clerk as well as Mr. Yanovich to kind of understand what was going on at the time and where the bylaws properly codified with what was voted at town meeting. And they were. So the sections for, I guess, 6C4A3 and 6C4A4 and 6 are not applicable because they're not actually within the bylaws themselves. It just seems to might have been just a confusion on what was actually recorded back in 2018. Likewise, the first portion of just 6C4 should actually be 6C4A.
I have the updated bylaws in my hand, the correct ones. It appears that the applicant did not use the updated bylaws for this. Is that correct, Patrick?
Interesting. Interesting enough, the subsections that he does note were part of the article from 2019 in the original motion, but they were never within the bylaws themselves. What's recorded and what you see in your new version, that was part of the subsequent motion from 2018, which effectively removed those 6C4A 1 through 6 subsections. I know it's a little confusing, but yeah, so where it says, 6C4A 3, 4 and 6, I guess they never really existed.
I think the way we solve this is in this request for a waiver, we just say does not match the bylaw. Is you okay with that, Bob and Suzanne, Drew? What do you think?
Ask
Just-
George too.
And
Say not applicable. The reference section is not in the bylaw.
But I want it noted in this that again, it's poorly crafted so that we're trying to find a waiver that doesn't exist in the bylaw.
Yep.
Okay. And that goes for both of those. C4A4. Same, I think that's for the next page.
Well, there is, so 6C4 at the top, it should actually be 6C4A. So that is applicable. That is within the bylaw.
6C4A4 is what I'm reading. Is that?
Oh, for this one? Yeah, so both 6C4A 4 and 6, it's the same thing. Those aren't technically within the bylaw itself. But the original one of just 6C4A is.
Nowhere in here does he request a waiver for 6C4A. He has waiver request for additional 3, 4, and 6. But again, it's showing that it's not well crafted. Does everybody see that?
Oh, yeah.
Yeah, I mean, I think the first one, 6C4, I agree, it's not pointing to the right subsection, but the description is pretty clear that what the waiver is looking for is to allow more than one principal building on the lot, which is the substance of 6C4A.
Well, we got another one on the last page that kind of tallies it up, the second to last one.
Yeah, but that's the one that doesn't exist anymore, or
Oh,
never did.
that's the one that
Never,
doesn't exist? Oh,
never
okay,
did
sorry.
exist. Yeah.
Nice. I like spending my nights doing stuff that doesn't exist.
Well, I think it does speak to how this process is backwards. Like,
Yep.
it's not our job to take a plan and say, here, board, figure out all the waivers I need. Like, the process is
Pretty bad.
my plans, and here's the specific waivers. And we're spending a lot of time tonight trying to figure out what waivers are being requested, as opposed to evaluating specifically requested waivers, which is
I
frankly
need a raise.
not the board's job.
I need a raise.
So on this.
Yeah.
What do we, for all these 6C4, Patrick, can you show us what you have on yours as far as your comments? We're looking at the site plan right now, which I appreciate having that pulled up.
Do you want me to bring up the site plan?
No, I want you to bring up the waivers list so we can see where, because I've got my list over. I'm on a separate computer. I'm looking at the waiver list, but I want to see what you have and what comments you've got on those.
So, I mean, I have the comments up, I mean, for what Mr. Petrosi was requesting, but in terms of comments within the waivers themselves.
The notes. You've been
Oh.
saying, and I want to see.
In terms of the notes that have been ongoing during this discussion,
Right.
yeah, I have nothing for 6C4 yet. I know we were just kind of going over the fact that 6C4, A, 3, 4, and 6 don't technically exist, but 6C4.
So we need to write that on each one of these.
Yep.
Does not exist.
Yep.
Because I don't want to waste any more time on something that doesn't exist.
Yep. So those are all as written within the notes.
Okay, can you pull that? I want to see that on the screen.
Yeah, I have it on my screen right now. Is it not showing?
No, we're still seeing the site plan.
Oh, hold on. Let me try it again. Can we see it now?
Yep.
Yeah.
All right. Yeah. Sorry
Good.
about that.
Okay.
I'll blame the laptop.
No, and now just scroll up for the start of, so 6. So the first one's 6C4. Again, it's not within the zoning bylaws.
No, so 6C4 it was the subsections that Ms. Petrosi noted that technically weren't within the zoning bylaws.
Right, but what 6C4 actually states is it's number of buildings per lot. That is what 6C4 is. And that's not, then this gets into something different. You see what if you look, 6C4 specifically, number of buildings per lot. That's not what he's asking for a waiver here, so. It's incorrect request,
Well, no,
not within the zoning bylaws.
well, if I may, so 6C subparagraph 4 is entitled number of buildings per lot. And then A talks about except where specifically provided elsewhere, all residential zoning districts, not more than one principal building constructed as a dwelling or so used shall be located on a lot. So I think what Patrick's pointing out is that where the waiver table says section 6-C.4, it should say, and it describes under the description, not more than one principal building constructed as a dwelling on a lot. The correct citation to the section is 6-C.4.A.
Right.
And so, and I think that's substantively what's described here. So I think that's just a Scrivener's error, if you will. And so the waiver request is to put more than one residential unit on a lot, basically.
Okay, so I guess earlier I said this whole project is based on 8 units on the lot. But how do you explain the next one where it's 6C4A3 and that's not any place in the bylaws?
Right, that one's not anywhere in there.
So
Correct. So that the language that Ms. Fitzgerald mentioned, so that is within the bylaw noted as 6-C .4.A on page 46 of the most recent version of the bylaws. The next 3 requests, for whatever reason, they don't exist. They never did exist. They were in an article from 2018 at the Springtown meeting, but there was a subsequent motion that basically removed them. And so that information, I had to kind of clarify with the town clerk and the building commissioner to find out what was the history and whether or not that ever existed within the bylaws. So that was information I found out only about yesterday. Could get an answer on, so.
okay, so Bob, what do you want to say for section 6C4?
I would say, granted subject to final decision on project plans, or something like that. I mean, I don't want to specifically say we're granting 8 buildings until everybody's going to grant 8 buildings. That's all. So I think it's just granted subject to final deliberation. And we're not even voting on it. So I think it's just more, this is like a straw poll kind of discussion right tonight. So I think we're inclined to grant it, but we're subject to final discussion of site plan.
Okay.
And don't we have to put an A on that too?
Yeah, I think if we grant this, then we would have to cite the appropriate.
This is his request for waivers. Please do not modify
Oh, all right, sorry,
his document.
sorry.
I just think it's important that we recognize what kind of information that we've been given on this. I don't want to.
Okay. No, you're right, you're right.
Patrick, would you make that note of, as Bob said, on 6C4? Pending deliberations on.
And I think we would say the same on 6C11.
Yeah.
I think on site plan, we've already had a discussion on this, that we're not, we're sitting as the site plan review board for purposes of this. So we're not waiving all of the site plan procedures under section, or the substance of section 13.
So would that be, would we do deny, or would you want me to?
Yeah, whatever we said. What did we say above when there was a reference to site plan review? I forget what we said. Deny as NA.
Right.
Okay.
Granted as to special permit not required, but not as to remaining substantive provisions or something like that. Or, I mean, you're just specifying that you're not requiring a separate review, but you're not necessarily waiving the substantive requirements.
Right. That's exactly right.
I don't have the stormwater regulations in front of me for this, so does anybody have them with them?
No.
I don't know.
I can try to bring them up really quick. So it's Article 2.
We're missing a whole shitload. I'm missing something. I'm missing waivers.
Article 2, applicability.
Waivers. Where are they? They were supposed to be in the printer. Print them out again?
So, Mr. Chairman, I believe it's the section of the stormwater management, chapter 49, chapter 499, article 2, applicability.
They, I'm just trying to see Article 2, erosion. I see a request referencing erosion control, but where is that?
It was in the section Walpole General Bylaws, Chapter 499, Stormwater Management, Article 2, Erosion Control, Section 499-16. So this looks to me like the provision that requires local permits for land disturbance, either a local land disturbance permit or a fast track permit. And
I don't even know what to.
Yeah, it's hard to know where to begin with this. I mean, maybe for now we treat it as town council suggested on the site plan review, is that we're waiving with respect to the requirement to obtain a land disturbance permit or a fast track permit under that section, but otherwise denied with respect to the, otherwise denied with respect to the substantive provisions or something like that, or for further discussion during deliberation.
Yeah, I'd even go further, because we spent a lot of time talking about the stormwater, and he's asking for a waiver that would involve any activity that will result in an increased amount of drainage, change in drainage patterns and water flowing off the property onto public or private, public way or property. We clearly said no to this in our long discussions, and they had designed a stormwater system that was supposedly going to meet that. So we had a lot of talk about that.
This is a pretty important one for this area,
Yeah.
like huge.
Oh, we could just put pending further discussion by the board.
Yeah,
If we're not,
That's what I think we have to do that, Paul.
again, we don't have to decide up or down on these tonight.
Right.
It's just, they'll be part of the final decision. And I think the next one is probably the same.
Same, yep. That's like probably one of the most important things in the whole area up there, in my mind.
Okay, and the sewer and water department asked us not to waive entrance fees, so that, at least for me, this would be deny.
Yep.
Agree.
And also with the building permits too.
Yep.
Okay. That is the list of waivers. Patrick, will you send those waivers out to everybody with the comments from the, that we have? Will you send that out tomorrow to everybody on the board?
Yes.
Okay, anything else?
I mean, I think, are we, I don't know if the applicant's still present, but are we going to close the hearing tonight? Or
Yeah, I know that the public's out there. If anybody from the public wants to make a comment, please come in. Raise your hand, Amy will let you in. And but we're looking to close the public hearing tonight, and this will be the last chance to have any input at this point.
We have one hand raised and it's Janice Sellett, so I'm gonna allow her to talk.
Okay.
Janice, whenever you're ready.
Janice, can you take yourself off mute and speak, please?
Oh, there we go. Sorry about that. I just want to take a quick minute to thank each and every one of you for all that you're doing and have done. And I, for one, truly appreciate it, feel the pain, and know that you have the neighborhood all around here in our best interests. And I wish there was some way I could help you out, but I just want to let you know that your hard work is truly appreciated.
Oh, thank you, Janice. That felt good. Thank you.
Oh, Thank you. It's so frustrating. It truly is. And I just wanted to let everybody know, including Ashley, if Amy or Patrick or whoever would speak with her. It's not an easy job, and we know what's going on. And it's hard when a neighborhood, and there's several of them in the town that are going to be changed forever, and you're trying to do the best. And we know in certain areas there could never be a best done for them. And it's a shame that some people just want to ruin the land. So anyway, it's been a very long night for all of you, and I just wanted to let you know that I do appreciate you.
Thank you very much.
You're very welcome.
Yeah, thank you. Good night.
Good night.
Okay, so next we have Tyler Hool. Tyler, whenever you're ready.
Hey, everybody. Thank you. Just wanted to mention, didn't realize the public hearing was closing tonight, so wrote a quick letter to sum up all my thoughts, sent it over. So just wanted to make sure, hopefully, I think, given that it's there on the town website now, hopefully that's some time to get my thoughts in there before you guys close this. So appreciate it.
Thanks.
Amy, did you get a letter from Patrick? I'm sorry, from Tyler?
I did, yes, and I posted it on the website, so it is there.
Okay, very good. Okay. Thank you, Tyler, for your letter and everybody's comments to help make a project better if possible. Okay, Town Council, any advice on closing this hearing?
Nope. I think you covered everything. If you're ready to close the hearing, I would take a vote, as I'm sure you will, to close the public hearing. And then you're obviously going to need some substantial time for deliberations on this. So I would just keep that in mind when you schedule votes, that you're only going to have 40 days to deliberate and issue a decision. So you want to give yourself plenty of time.
Is our drop dead date tomorrow?
No, you have to close the public hearing by tomorrow.
By tomorrow, that's what I
Yes.
meant. So they were both on the same day, Doopy and Burns, same day? Okay,
I think it was because of extensions. That's what I confirmed with Pat
Okay.
today.
okay.
And we've been at this for a long time, and I think there's no need to just keep continuing it out. There's still, I think what we saw from tonight doing the waivers, there's a lot of things that are still unanswered on this, so. Okay, including public safety issues, so, okay. Any final comments from board members? Okay, could I have a motion to close case number 0520 Doopy Street comprehensive permit?
So moved.
Moved by Suzanne,
Second?
second by Bob. Any further discussion on closing this hearing? Okay. Roll call vote to close the hearing. Bob Fitzgerald,
Aye.
Drew Delaney,
Aye.
Suzanne Murphy,
Murphy, aye.
and I'm John Lee. Aye. Okay. The hearing is closed, and that means the clock starts ticking on the time to get 40 days to get this decision filed. Patrick?
Issued.
What?
Issued.
Issued?
Yeah.
Issued.
Decided, basically.
What's that?
You'll have time. Excuse me. You'll have time to file it with the town clerk after that, but you only have 40 days to deliberate and finalize your decision.
Okay.
That's going to end up getting filed.
Right. Okay. So we have 40 days to have our final, because we'll still have hearing. We'll have discussions on this. We'll craft it. Patrick will start a draft decision and get that out to the board members. And then, yes, within 40 days, we will have a vote on it within 40 days. We won't bring it down to the last few days. Hopefully we won't. Okay. Okay, anything else? And Amy, I know we have some minutes that we're gonna do. Do we have anything?
Oh, wait, John, I
Yeah.
would are you going to schedule that now? 'Cause-
Yeah, I was gonna say we should set a date. How about 26?
Okay,
Does that work for anybody? Because we're doing the other one on the 19th. We don't want to do them on the same night, I don't think.
No,
How about the next week after that? Does that work for anybody?
are board members okay with that? Amy, are you available?
Yeah, that's fine. You don't want to do it on June 2nd?
No, I'd
No,
rather,
we might need, I think we might need two, no?
yeah, I'd rather, let's see where we're at on the 26th. I hate to just,
Yeah,
Bob, are you okay with
Just
that?
checking. Yeah, I'm just checking the.
Drew, how are you?
uh,
You okay for the 26th, do you think?
Yep.
Yeah, I think that
George,
works.
are
for-
you?
I am. Yep.
Okay, good.
Okay. So, George, you'll be helping, who's going to be drafting this? Patrick, you're going to
I-
get all the bones to it, or?
Yeah, I think it will be Patrick, and
Yep.
I'll work with him on it, but it's up to you. I mean, I can do it too. It's up to you and Patrick.
Right. It makes more sense, Patrick. You start drafting it with all the dates of the hearings, all the procedural things. And then we'll get in based on the waivers. That's how we draft the decision is based off of that. Have you done these before, Patrick? A 40B decision?
Just with the most recent modification, but I can go back and forth and talk to George if need be on some of the language.
Yeah. And
Yeah, and there's a nice template to it, a setup that, I can provide to Patrick, kind of how to set it
Yep.
out. And I mean, he's done an unbelievable job on the decision so far that he's done for you. So I'm sure he'll be a quick study on it. But again, I'm available to do it if you want me to, but
Yeah.
it would typically come from your staff first, subject to our review, and then your approval, obviously.
Yeah, I have no problem writing it and obviously coordinating with George to make sure the language is correct.
okay. And I know, Amy, you've also been a big part of this one from the beginning. So any help that you can give to Patrick and George is appreciative. So,
Sure, timelines for everything that went on can be provided to them for sure.
okay. Yeah, particularly because we're going to have to include all the dates of the hearings and things like that. So thank you, Amy. Okay. Okay, so we will have and it's not going to be a public hearing, but we'll have a meeting on the 26th, where the only thing on the agenda for the zoning board will be the decision for Dupy Street.
Is that 7 p.m., John?
Yes, 7 p.m.
Great.
Okay. Okay, anything else, board members? Okay, thank you.
Uh,
You're welcome.
You mentioned the minutes. I don't know if we're gonna.
Yeah, I do want to do the minutes.
Okay.
Let's
I
say
think
you're
goodbye to George. He's
Gotta go.
tired. Bye, George.
Oh
Thanks,
no,
George.
I'm not tired. I'm all ready to go. Thanks very much. Good night. We'll see you in a
Thanks.
bit. Bye.
Sorry, I just wanted to let him go.
Yeah.
I would have gone with him if I could, but I don't even know where the hell he is.
Okay, so we have two sets of minutes, one from February 11th and the one from February 21st, I believe. I'm sorry, February 22nd. So it brings up a lot of the issues. I mean, I've already reviewed them. I didn't have any comments, actually.
When did we get him? I don't even see him.
Oh,
They've been here a while?
no, I mean, more than
Oh,
a few days. And also KW Steel is on this one. So as we know, that one's being appealed. So
Yeah, I did have some comments on that because I think that was the one where we had like the votes were kind of we needed clarification from George as to how we should formulate the votes, and then we had one vote, and then we got more advice from George about another vote, and then we took a second vote. And
Yeah.
I just want to make sure that the discussion there is consistent with the because George reviewed the final decision in that.
So I actually verbatim took the wording from the final decision for the minutes. Oh, yeah, for the minutes.
Okay.
yeah, and I I read it and I'll tell you, the minutes made more sense than the meeting did, so.
Yeah.
If you recall.
Um,
Yeah,
But
I don't have any of these. Yeah.
I think they were with the package that we got for this meeting a couple days ago. Is it when you sent it out, Amy?
Yeah, they were with probably your agenda that I sent.
Yep, they were. So,
All right.
so unless somebody has comments on the February 11th ones, which I went through and I was okay with it. Anybody?
Yeah, I'm not sure what the, so Suzanne didn't participate in that. She, and so in the vote, like, for example, the vote on shows an abstention by Suzanne, and I'm not sure if there should be just no vote at all from her, if she's not participating.
Which one was that, Burns?
No, for
no,
KW.
KW Steele.
Oh, no, I can't abstain. I'm out.
You're
Right.
out, okay.
Okay.
Oh, yeah, no abstention.
All right.
I didn't sit in the hearing. I actually wandered around. No, I actually went out and watched, I think it was the Bruins that night. I can't remember.
Actually, I don't see Suzanne's name in any of this.
No, it's just on this. So the
I
third
put
page
Suzanne
of-
Murphy recused herself from this hearing in the beginning.
Yeah, that's what
Right
it should
under the
say.
case. Yeah, right under
Yeah.
the case number, the
And
minutes.
her name doesn't show up in any of the votes.
Which
Yeah,
is good.
no, on the, well, it says Murphy abstained, and I
Oh,
think
yeah, there it is. It does say abstained.
on the third page
Yeah,
towards the bottom.
yeah, it does say that. That's, yeah. Take that out, please.
Oh, okay.
Good spotting job, Bob.
That was to close the hearing, right? Okay.
Okay.
Gotcha.
Yeah. That's,
Yeah, I just, I'm not sure what the rule it specifically is, but I think when you recuse, you can't even abstain. You're just not even
No, yeah,
part of
you're
the-
right.
Part of the
Oh,
deal.
no, you can't, you're out. You
Yeah,
tapped right out. There's no abstaining happening.
okay.
okay.
And I was okay with the February 22nd minutes as well.
Okay. Okay, could I have a motion to approve both the February 11th minutes and the February 22nd minutes?
So moved.
Just subject to the deletion of Suzanne. Yeah. Second.
Moved by Suzanne, second by Bob. Any further discussion on the minutes? All those in favor, roll call vote. Bob Fitzgerald,
Aye.
Drew Delaney,
Aye.
Dan Murphy.
Murphy, aye.
I'm John Lee, aye. Okay, so
Yay!
Just for housekeeping purposes, are there other minutes out there that we're behind on?
Oh, for sure. They're novels,
Okay.
so you'll be getting them throughout
Okay.
the week for the next meeting on the 19th.
okay, great. Thank you, Amy. Anything else for anybody? Patrick, anything for us?
No, looking forward to writing those decisions, and we'll see you on the 19th.
Moving it along. Okay.
Yep.
Okay, I'll see everybody in 2 weeks. Thank you. This was painful.
We're done, though.
Motion
I'll
to
make a
adjourn.
motion to adjourn.
Motion to adjourn. Yeah, made by Bob. All those, is there a second on that?
Second.
And all those in favor, say aye.
Aye.
Opposed, abstained, so carried. Good night, everybody.
Good night, guys.